May I have a lordship
Yes.
kind leave to mention, my lord, finally recapitulate that your lordship was pleased to allow my amendment application, my lord, on 20th of last month, my lord. May.
Yes.
But in this matter, my lord, what happened? Order in terms kindly come to the last page of the matter order.
Yes.
Last paragraph, my lord. Let there be an order in terms of prayer B, C, D, and E of the master summons. Lordship got it, my lord?
No. Oh, B, C, D.
B, C, D, and E of the
Yes.
master summons. My lord, what happened? There is a copy of the master summons. It appears that, my lord, D is the proposed amendment indicated an underlined reading of the copy written statement. He had to mark with the letter B allowed. That is there. My lord, the department be directed, C. The department be directed to carry out such amendment within 3 weeks from the date of the order within such period as, my lord, order was made on 20th May. My lord, this holidays intervened, my lord. My lord, I have taken.
Okay, let it appear as to be mentioned.
My lord, tomorrow.
Yes, serve notice upon the other
My
side. Day
lord,
after tomorrow.
Day after tomorrow, because
Day after tomorrow, serve notice upon the other side.
my lord, I will.
Lordship, may I kindly be permitted to mention a non-contentious probate matter for final disposal, Lordship? There were certain corrections that required to be done, so that has been now completed. The 2009 application, Lordship. It was all completed. Grateful, Lordship.
This is civil suit number 179 of 2008. Your Lordship, this is appearing at the instance of an order passed by the Honorable Supreme Court, wherein the matter has been remanded back for adjudication afresh by Your Lordship. Your Lordship was pleased to fix the matter because of a timeline prescribed by the Honorable Supreme Court on the 11th at 3 p.m. Your Lordship, what has happened, I appear on behalf of the petitioner. We have applied for the certified copies of the documents because there's been a change in the advocate on record for this matter.
On 11th, the matter will appear.
On 11th at 3 p.m. it's fixed, Your Lordship. So just we are praying for.
So anyway, you take steps on that day, mention on that day, upon notice to the other
Your
side.
Lordship, I'm mentioning upon notice today just to save Your Lordship's precious time, Your Lordship, in mentioning the matter because it's fixed at 3 p.m. We'll require at least 2 weeks to obtain the certified copies.
But any order has to be passed in the presence of others. Okay.
Your Lordship.
Let other sides submit what they have to say. Thereafter, necessary orders will be passed.
Grateful.
Mention on that day, serve a notice also.
Grateful, Your Lordship.
Kindly be permitted to mention.
Yes.
But kindly recapitulate the memory of Your Lordship.
No. What do you want to mention?
Mention regarding the receiver appointment.
Yes.
Appointment of receiver.
Order passed.
Yes.
Order passed. Anyway, serve notice. It will appear day after tomorrow as to be mentioned. Serve notice upon the other side.
Day after tomorrow.
Day after tomorrow has to be mentioned.
Tomorrow another matter is coming. The discharge of the administrator.
Whatever it is, if you want to include, you serve notice. Let it appear as to be mentioned. Day after tomorrow. Serve notice upon the other side.
Original side, item number 1.
This is a matter which has been assigned to Your Lordship. Application for setting aside of a consent decree by the defendant. Lord, the pleadings are complete, so Your Lordship can fix a date for hearing.
Okay, let this. You are for?
Lordship, I am for the intervener in this matter, Lordship.
You are for the defendant.
I am for the plaintiffs, Lord, in the suit.
Yes.
Lord, intervention, Lord, at this stage has not been.
Who is for the defendant?
I don't know, Lord. Nobody is appearing, but there's the advocate on record is Mr. Lal Ratun Mundol. We can communicate, Lord, Your Lordships, whatever order Lordship passes.
Lordship, there were 2 applications also filed in this suit, Lordship.
Anyway, so
those applications are assigned to another bench. Your Lordship is only concerned with this application for
only this. GA 6 of 2016 is assigned.
Yes.
GA 6
to
of
Your Lordship.
Old number was GA 1215.
Yes. Yes.
Yes, record an order. Mr. Call, learned advocate for the plaintiff. Yes, give your name also. So and so. And learned advocate for the intervener are present. This application is special. This application GA 6 of 2016 is specially assigned. let it appear on 16/6/2025.
Lord, kindly fix it at 2 p.m. Lord, I'll inform the learned advocate for the defendant.
16/6/2025 at, shall I keep it at 2 p.m. or 12:30?
12:30. Kindly keep it at 12:30.
At 12:30 p.m. Learned advocate is requested to intimate the learned advocate for the defendant by notice.
Much okay. Much okay.
Item number 2,
I am appearing for the
Item-
petitioner
Yes, yes.
in this matter only. So your lordship have a look at,
G18.
yes. Kindly have a look at the last order, my lord.
So other side is not here.
No, this is a, there was no other side because all the trustees, Shebaites have filed the application,
Okay.
praying for leave to enter into a development agreement in respect of the property. My lord, your lordship has a,
Let me see.
only there was a direction to serve upon the tenant of the property. That order we have communicated
And they have all been served.
and they have been served. I am filing the affidavit of service. Your lordship has a look at 7th February 2025 order.
এটা দিয়ে দিতে হবে স্যার।
This is the affidavit of service.
Affidavit of service আছে?
না,
আরেকটা,
এটা-
এটা আরেকটা।
এই অর্ডারটা
So
এটা
tenants room number 1, 2, 2A, 3 and 4 and 5 to 8.
Lord, kindly have a look at the order of 7th of February. I have given the new affidavit of service. Page 8,
Affidavit
kindly
of
come to
service,
page 8.
Order ta kothay?
Order is annexed. I don't know whether the order is in your lordship's file.
So this is the fresh affidavit of
Yes,
service.
fresh affidavit of service.
So you have affirmed this on 20th of February.
Yes,
pursuant to this
pursuant to the order of 7th of February.
Yes.
There was an earlier affidavit of service filed. Then, my lord, kindly see, submit that pursuant to order of 9th January, notice of the application was sent to the tenants. However, all those consignments have returned to the sender with the postal endorsement addressee could not be located because the affidavit to serve afresh upon the tenant and
Tenants.
file affidavit of service.
So tenants have been served according
Yes.
to you.
Well, the tenants have
All
now
the
been,
tenants.
all the tenants have been served. And kindly see page 10, item delivered addressee for all.
আমরা বলেওছি এখানে affidavit।
Yes. Item delivered address.
Yes. Now kindly have a look at my application.
This is one by one টা নিয়ে we are concerned.
Earlier did the tenants appear?
No, that is why fresh service was directed.
None of the occasions they appeared.
No.
Okay.
Now, my lord, I am,
Suit of 1903.
yes, with a
Yes.
scheme that we can,
Which page?
my lord, kindly come.
Sir, page 16,
Scheme is at page 16.
the relevant portions are page 54 এ।
Kindly come to page 54.
স্যার, আমি বার করি। যেখানে in the scheme, I think এই যে, হ্যাঁ স্যার, the trustees are at liberty to
Oh,
make
yes.
At page 55, your lordship will see.
Yes.
Trustees shall be at liberty to make formal application to this court in this suit whenever they find it necessary to do so. Now, my lord, now today the problem is
So
we
you
have,
want to enter into a development agreement?
yes, yes.
No.
Is there any proposal offer letter by the developer?
Yes, yes.
81.
Kindly come to page 81.
This is only with respect to one by one.
Yes, page 81.
Kindly see, this is the offer which we have got from the proposed developer.
Varun Mundra. Varun Mundra.
That is 1 kata 3 chitaks of the
Yes, yes, yes.
of the
Only
trust property, suit
Yes.
property.
suit property. One of the trust properties.
One of the trust property. So
One
they
by
have,
one Babulal Lane.
Fully tenanted.
so they have sought
Completely
to-
tenanted, my lord. There is practically no income accruing. We cannot maintain the trust.
And what is the consideration they are willing to pay?
So for
Lease for 99 years.
Yes,
99
it's
years
for 99 years
with right to develop.
and the right to develop.
The grant assignment
And the
service.
lease premium, they have said, my lord, 14 lakhs. Advertisement করা হলো না।
14 lakhs means at one time.
ওটাই ওদের কাছে একটা stock, সেটা দেখুন কি বলে। হ্যাঁ, ওটা One time.
One
And
time.
negotiating with all the tenants.
And my lord, they will have to negotiate with all the tenants, my lord. It is completely tenanted.
So
Yeah,
14 lakh,
presentation.
a one-time payment.
One-time payment.
That is lease for 99 years.
Yes.
Any portion allotted to the this for the trust? Any one flat or something like that?
Entirely.
Anyway, that agreement has to be entered
Yeah,
into.
first an agreement has to be entered into.
So thereafter, that agreement has to be filed by you.
Yes.
That proposed
yes,
agreement.
Yes. Subject to your lordship considering this person.
Whether you will be permitted to enter into an agreement,
Yes. Yes.
and thereafter that draft agreement has also
to be filed.
to be finalized
Yes. Yes.
for final approval
Yes.
to enter into that agreement.
এটা পুরোনোটা, এটা
হ্যাঁ,
পুরোনো।
তাই জন্যই তো বলছি।
এটা অন্য প্রপার্টির রেসপেক্টে যেটা ভেঙে পড়ে গিয়েছিল, অর্ডারটা পড়েছে।
There is a similar order passed in respect of another property which had already collapsed.
Page 83.
Yes,
Yes, page 83. This is premises number 2B Babulal Lane.
নেগোশিয়েট, ইয়েস।
হয়েছিল।
হ্যাঁ, ওটাই হয়েছিল স্যার। বললে ওদের অসুবিধা।
So terms and conditions are to be settled.
Yes, terms and conditions are to be settled. May I do one thing, my lord? We can have, subject to an order being passed, we
After
can have
entering into the, you can find the
we can
draft
fi-
agreement
we can have a draft agreement and file it before your lordship
for granting the final order
for final order.
to execute that agreement.
Yes.
So anyway, yes. Mr. Sen, learned advocate for the petitioner is present. None appears for the tenants of the trust property in spite of service of notice. Heard Mr. Sen, learned advocate for the petitioner trustees. Let this matter appear on 13/6/2025 for orders. I'll pass orders on 13/6.
Your lordship can say, my lord, if the petitioner will enter into a draft agreement and
Anyway,
file.
whatever it is, I shall pass. Today I am not passing order, I shall pass it on 13/6.
13.
Let affidavit of service file be kept with the record.
Obliged.
Item number 3.
My lord, in this matter, my lord, I am paying for an accommodation, my lord. Kindly, my lord, make it northeast with me.
Okay, item 3.
Item
You are for petitioner?
for competition.
Okay, item 3, not this week.
Item number 4.
My lord, item number 4, I am appearing for the applicant, my lord, in this matter. My lord,
GA 100
last-
your application.
my lord, I want to withdraw the application, my lord. On last occasion, if this order passed on 19th March, my lord, I had submitted it before this honorable court. The honorable court is of the observation that to furnish a written instruction. My lord, I have got the written instruction.
Your lordship, I am appearing on behalf of the defendant number 10 association. I have been served and I have no objection.
You are for the plaintiff.
My lord, not for the plaintiff, my lord. I am for the applicant, my lord. I am a it's my petition, my lord. My lord, it's a representative suit.
No, you are representing the plaintiffs.
My lord, it's my application, my lord. I'll tell. I'll state the facts in a nutshell, my lord. There's a building in Gamak Street, which was developed by the plaintiff and which was developed by the defendant number 1. My lord, after developing the said building, the developer is no longer traceable. That's why the owners, who has purchased the property by way of a sale agreement, they had filed this suit for execution of those agreement. So in that particular suit, from time to time, these applicants who had purchased the property, they used to file this application, and court used to appoint a special officer who used to execute the deed on behalf of the developer. My lord, one of such application is GA 101. My lord, here the person is no longer willing to proceed with the
This
application.
application will go, the suit
My
will
lord,
remain.
The suit will remain. The application, this application
will
will be withdrawn. 101.
Yes. Yes, record an order. Learned advocate for the applicant.
My lord,
What is the name of the applicant?
My lord, it's Drupati Guliram, my lord, is in page number 2 of
Okay,
the
Drupati Guliram alias Sunita Guliram Jivatram, who has filed application under Order 1, Rule 8 CPC in the instant suit is present. It is submitted by the learned advocate that the applicant does not intend to proceed with the application under Order 1, Rule 8 CPC. Stop. Learned advocate furnishes the written instruction issued by the applicant. Stop. In the facts and circumstances, application under Order 1, Rule 8 CPC being GA 101 of 2024 stands disposed as withdrawn.
Much obliged, ma'am. My lord, item number 5 is also related to is concerning the same building. Herein, initially the order was passed for paper publication. We have carried out the paper publication, my lord. Thereafter, the special officer was appointed, my lord, by order dated 19th March.
Is it the same prayer you are making?
My lord, no, my lord.
No, what is the prayer? Let
My
me
lord,
see.
my lord, if my lord,
105.
my lord, herein I am just simply seeking for extension of time for the carrying out the execution. My lord, the
Where is
special
the
office.
order? Let me see. Yes, record an order.
My lord, the special officer is yet to carry out
You
the
are for
execution, my
the,
lord.
you are for the
applicant, my lord.
learned advocate for the applicant.
My lord,
What is
I seek, my lord, 3 weeks time for.
No, applicant. What is the name?
My lord,
Draupadi.
no, it's a separate applicant.
Oh,
My lord,
applicant Univat.
my lord, it's not Univat.
Univat Vanija Private Limited.
My lord, Gurmukh Das.
Oh, that was the.
My
No,
lord,
here in this application it is stated. Oh, this is applicant's nominee.
yes, my lord. My lord,
Okay.
page number 105.
Page 105.
Application 105, page number 2, my lord.
Page?
Page number 2.
Yes, learned advocate for the applicant, Gurumukh Das alias Gurumukh Lakshmani is present in court. Learned advocate submits that in terms of order dated March 19, 2025, directing the special officer to execute and register necessary deed of conveyance on behalf of Western Building Corporation, the same could not be completed. Stop. Learned advocate submits that further time be granted to comply the order dated March 19, 2025. Stop. In the facts and circumstances, time granted by order dated March 19, 2025 is extended for a period of 4 weeks.
4 weeks.
Stop. Let this matter appear on 7/7/2025.
Much obliged, my lord.
Gratefully, Your Lordship.
Item number 8. 6, sorry, item number 6.
Yes, item 8.
Item 6.
Defendant numbers 1 and 2 in item 8, but I think
Item
there was a misconduct.
Item 6. Okay, pass over.
Item number 7.
May it please, my lord, this is my application, my lord, for intervening, my lord, in a suit of 1982 and for being examined, my lord, pro interesis suo, my lord, on the last 2 occasions. My lord had asked me to serve, my lord, and come back on the parties, my lord. I have done so. My lord, may I hand over, my lord, the affidavits of service? I have specifically, my lord, ensured that it has been served on the plaintiff, my lord, the affidavits of service. My lord, may I make over the, my lord, the affidavit of service?
I appear for the defendant number 4 in this matter, my lord. I don't really stand in the way of the application that's been placed by my learned junior friend. My lord, if in case the case is made out, my lord, I don't stand in the way of orders as prayed for being passed.
This is your application, GS7.
Yes, my lord. May I press it, my lord?
Plaintiff is not here, I see.
Last
You are
3
praying for an
occasions.
interim order.
But I have not, my lord, there's a prayer for interim orders, my lord, but I'm not pressing it, my lord. Because the prayer, my lord, is for me to intervene, and so my evidence, my lord, may be taken and a deed of conveyance, my lord, can be executed. May I, my lord, briefly indicate what the issue is, my lord? I am, my lord, the successful purchaser, my lord, in respect of a flat, my lord. My learned senior friend, my lord, is representing, my lord, the developer, my lord, who arguably, my lord, has right title and interest over in respect of, my lord, the entire building where the flat is situated, my lord. Because of, my lord, a contempt proceeding, my lord, and orders passed in the main suit directing, my lord, my learned senior friend's client, my lord, to maintain status quo, my lord, they cannot execute a deed of conveyance in my favor. My lord, on oath, my lord, my learned senior friend has taken a stand in the contempt proceeding, my lord, that as on the date of the status quo order, the property was no longer theirs. So therefore, there's no question of the status quo order being binding on them. Consequently, there's no question of contempt at all, my lord. The contempt, my lord, has in fact been disposed of, my lord, by an order of 2015, my lord, by Justice Sen, my lord. Therefore, as on date, my lord, nothing prevents my learned senior friend, my lord, learned senior friend's client from executing a deed of conveyance in my favor.
What was the suit for?
Well, it's a suit for management of a company, my lord. This is an old company suit, my lord. Against, my lord, my learned senior friend's company. My lord permits me, my lord, I can only show a few.
I'm just giving it on Wednesday. On
My
that
lord,
day, if the plaintiff does not come, I shall pass orders.
Only one thing, my lord. This is really an innocuous application. The plaintiff has been served twice over, my lord. We'll see from my lord's orders. This is the 3rd or 4th time possibly that the matter is appearing. This particular application, they've been served twice over. The plaintiff, I'll indicate what the suit was about, my lord, because I am privy to the suit's proceeding more than perhaps my learned friend. But the plaintiff is a family member of the overall family which ran my client's company, or rather my client, which is a company. It was a closely held family company. The disputes and differences which arose between family members, for which reason the plaintiff has come to this honorable court, my lord, seeking certain release, whatever, whether that is meritorious or otherwise is not of concern at this stage. Now, this company held lands. It was a development company. It really was in the business of real estate development. One of the lands in question was developed. A flat in that particular plot of land was sold to my learned friend's client, the petitioners, applicants. My lord.
That means
Before
agreement was entered
there
into.
was an agreement entered into. There was money exchanged.
Conveyance was not executed.
Conveyance was not executed. Agreement executed. Possession handed over. Money paid. Everything done. Only conveyance is left to be done. Before that, my lord, even after the money has come in, even after the agreement for sale is coming, the suit is filed subsequent to that. Order of injunction passed subsequent. Therefore, as on that date on which the order of injunction was passed, out of which the contempt arose, nothing survived. The plaintiff today perhaps is not even interested in conducting the suit. We kindly see, even otherwise, the suit has been appearing in the list. The suit itself is liable to be dismissed or default at this stage. Thrice over the plaintiff has been served, then chosen not to appear. This is a bona fide purchaser of a flat. I intend to execute and perform my side of the deal, and execute the deed of conveyance. We kindly have a look at the contempt order that's been passed. I think that will clarify it.
Page. But that contempt order, my lord, will find at volume 5 of my application, page 654.
Page 654.
18th of September 2015.
654.
654, my lord. Volume 5 of my application. Dealt with, my lord, a similar situation, my lord, where monies were exchanged before the status quo order. My lord, the learned single judge rightly holds that no contempt.
That means contempt application was dismissed.
Disposed of, my lord. This is a similar situation, my lord, where a prior, my lord, a transaction had taken place, my lord, because the learned judge holds, my lord, at that point of time when the interim order was passed, consequently those units, those flats, my lord, will no longer remain properties of the defendant number 4.
So status quo, that status quo order is still continuing.
Status quo order is
So
still
if
continuing.
that is, if the permission, if,
May I, my
it is
lord?
modified, then that can be done.
There's no question of modification at all, my lord. My lord need not modify the order, my lord, because as on that date, my lord, the flat, my lord, which my clients, my lord, hold, had already changed hands to me, my lord. Only simpliciter and execution of conveyance was, my lord, outstanding.
Yes.
That was the only thing, my lord, left. I was, my lord, the bona fide assignee, my lord, of the right in respect of that.
So now at
Session also
present,
taken over.
now at present, which order is to be valid for the defendant to execute the
My lord,
sale deed?
possibly, my lord, if I may only assist, my lord,
Yes.
possibly no variation or, my lord, modification of the status quo order is at all required, my lord.
No, status quo means, you see, nothing can, now no change of title, ownership, possession, nothing can be done.
My lord,
Status quo.
may I show, my lord, the status quo order, my lord?
Yes.
My lord, kindly takes, my lord, the first order, my lord, that's 3rd of April 1990. My lord, that's at page 76, volume 2.
Page 76.
I will only, my lord, show the relevant part, nothing else, my lord. Sorry, my lord, page 146. Page 146, my lord, that's the typed copy. Volume 2. Page
Yes.
146. At, my lord, page 147, second paragraph. May I, my lord, place it, my lord?
Yes, yes.
My lord,
Page 147.
Second paragraph, my lord. Considering the facts and circumstances of this case, it is ordered that the parties will maintain status quo in respect of the properties, my lord, kindly notes, belonging to the parties in suit, and the respondents will pay a sum of so and so to the plaintiff petitioner without prejudice to rights and contentions. Kindly, my lord, notes belonging, my lord. Now, my lord, by a subsequent order, the single judge, my lord, clarifies what properties would mean, my lord. Kindly takes, my lord, the next order. That's of 1st of June 1990 at page 152, same volume.
Yes.
The operative part, I'll only show that, my lord, page 153, second unnumbered paragraph, my lord, of that page.
Yes.
Starting with, my lord, considering the facts and circumstances of this case.
Yes.
It is ordered that the properties mentioned in the order dated 3rd of April 1990 would only mean and include immovable properties and not movable properties. That is, the said order of status quo would only mean immovable properties belonging to 3 defendant companies. On affidavit, my lord, my learned senior friends, my lord, client had taken a categorical stance which has been accepted, my lord, by the single judge in 2015, that as on that date, my lord, as on the date of passing of the status quo order in the balance sheets, my lord, the flat was no longer reflected, my lord, because the money had already been paid and I was already in possession of it. My lord, balance sheets have already been annexed, my lord, to my to the alleged contemners, my lord, affidavit in opposition to the contempt application.
That is page?
My lord, the contempt application is the opposition, my lord, their opposition to the contempt application is at page 177, my lord, volume 2. My lord, I'll only show, my lord, what has been pleaded there, nothing else.
Yes.
My lord, only kindly takes page 211 of volume 2, nothing else. This is, my lord, their affidavit in opposition to the contempt application.
Yes.
My lord, kindly notes para L that's appearing at page 211, internal page 18.
Yes, between 1975.
Yes, my lord. May I only place it, my lord? Between 1975 and 1982, all the said 73 flats, my lord, that's the entire building, my lord. All the said 73 flats, together with covered and open car parking spaces and servant quarters, save and except one shop room on the ground floor of the said premises constructed by the alleged contemner number 2, were agreed to be sold. The alleged contemner number 2 received the agreed consideration, therefore, and handed over possession to the respective purchasers pursuant to the respective agreements. My lord, this includes me as well. The receipt of the entire consideration happened between 1975 and 1982. In this frame of mind, my lord, kindly notes when the interim order was passed. That's 3rd of April 1990 and 1st of June 1990. Yes.
So nothing took place pursuant to the interim order.
Correct.
All were prior to the status.
Yes, my lord. And these averments, my lord, have been accepted by the learned single judge in 2015, dismissing the contempt application.
And your client is in possession from which
My
year?
client, my lord, is in possession from. My lord, I have paid, my lord, in 1986. My lord, the assignment in my favor took place on 30th of June 1986. And
Yes.
my lord, I have been in possession.
87 is the date of suit.
87 is the date of
Yes,
suit,
and
my lord.
you took possession.
My lord, from 30th of June 1986, my lord, I've pleaded that in para 8 of my application. That's at page, my lord, 6.
Only now you, what have you prayed for? That.
My lord, kindly takes, my lord, my master summons, my lord.
Yes.
My primary prayer, my lord, is prayer A, my lord.
Yes.
And then, my lord, B.
Yes, to intervene.
A and B, my lord. If it is, my lord, my learned senior friend's contention, my lord, that the status quo orders do not impede them from executing a deed of conveyance, my lord, there's no bar in granting prayer B.
This application really has been filed out of abundant caution. There was possibly no requirement, but it's been filed out of abundant caution. My lord, will kindly clarify that I am free to execute the deed of conveyance in favor of my learned friend's client.
You're now
That's
praying
it.
for prayer A and B.
A and B, my lord.
A is a formal order.
Yes.
B is the real substance, my lord, which is required from my client's end to be done. My lord can pass that order, my lord. Nothing
Yes.
stands in the
Learned advocate for the applicant, Mr. Sen, learned advocate for the applicant.
Lord, may I have my lord's leave? No.
Yes, yes. And you are for defendant number 4.
Four, my lord.
And
My
learned
applicant
advocate
record
for
is-
the defendant number 4 is present. None appears for the plaintiff in spite of service of notice. Heard learned advocates on GS 7 of 2025. Let this matter appear for orders on 16/6/2025.
Deeply obliged, my lord.
Affidavit of service file be kept with the record.
I'm grateful.
Item number 8.
My lord, I am appearing for defendant numbers 1 and 2 in the matter.
I'm appearing for the defendant numbers 3 to 6.
Ma'am,
9, all the rest of the defendants.
Your Lordship, I appear for the plaintiff. This is my application.
Item 8.
Item number
G8.
8, Your Lordship.
G22.
Yes, sir.
Affidavits have been exchanged, Your Lordship. This is an application brought about by the plaintiffs to bring before this honorable court certain discrepancies and anomalies which has been found in their valuation report filed by the valuer, Mr. Shorvojit Dotto. So this application is basically to bring before this lordship, bring before this honorable court the anomalies and the discrepancies, Lordship.
The affidavit exchange होंगे जो हमारे
Affidavits, sir. You want to?
Yes, what is the ground of challenging the valuation report?
Lordship.
My lord, just to cut short the matter once,
Yes.
because the report of the valuer is challenged, it is expected that the valuer should have a voice of representation.
Valuer is
Because it-
served.
Yes, Your
Because
Lordship.
in his absence, this application cannot be decided. There are
Lordship.
these are all technical
Who is
objections.
representing anybody representing the
I-
valuer?
The valuer himself was appearing
Yes.
all along. So because it's an old application, Lordship will see of 2023, since then umpty number of
No,
times the
valuer
matter
is
has
served
appeared.
with this copy.
Valuer has been
Yes,
served,
and he
Your
was
Lordship.
appearing also.
On the
So
same
let
day.
this matter be taken
Can
up
you serve him a
in
notice?
his
Let it appear
presence.
next Monday.
Lordship.
Then let it be after 2 weeks because my clients have not used any affidavit. So, my lord, in the meantime, I shall file my affidavit, my lord.
Yes, record an order. Learned advocate for the plaintiff and learned advocate for defendant number
1 and 2.
1 and 2. Yes, you are appearing for?
For 3 to 9.
And learned advocate for defendant number 3 to 9 are present. As this application relates to taking exception to the valuer's report, and the valuer is not present today, in the interest of justice, the matter stands adjourned till 25/6/2025. Affidavit in opposition shall be filed by the defendant number 3 to 9. You are for 3 to 9.
Ma'am.
Yes, Mrs. Menat, you are for 3 to 9.
3 to 9.
Shall be filed by defendant number 3 to 9 within 1 week. Reply, if any, within 4 days thereto. Let the matter appear on 25/6/2025.
And the valuer should be informed of the returnable date. Otherwise, he'll not
Lordship,
know.
I'll issue a notice
Intimate.
upon the valuer.
Yes, learned advocate for the plaintiff is requested to intimate the valuer by notice.
Lordship, grateful, Lordship.
Item number 9.
9, I appear for the plaintiff, right?
But I am appearing for the intervenor application.
There is an intervention application, my lord, addition of application
here
by them
16
for addition of party.
Here 16 is for
Well, for addition of party, my lord.
by the
By my
intervener.
lord, my learned friend's client, my lord.
So you have filed any affidavits to that?
My lord, we have filed opposition. Thereafter, my lord, they filed reply. We filed
So-
another opposition, my lord. Now, my lord, on the last occasion, your lordship was pleased to, my lord, allow them to, my lord, file a reply to our opposition, my lord.
No, opposition is filed by you to their application.
Opposition filed by us to their application.
Yes.
Thereafter, my lord, in reply, my lord, they disclose certain new documents. So, my lord, we also dealt with that as well.
Oh, in reply, they have dealt with new documents and you have filed supplement
We have filed
affidavits to
supplement
that also.
My lord.
Yes.
And my lord, my lord,
Today I am filing
possibly they are filing, my lord,
reply to the supplementary affidavit.
a reply to that supplementary.
No, question is in affidavit in reply, you have disclosed some new documents.
Yes, my lord.
To which you have filed
My
opposition.
lord, my lord.
And you are filing reply to that.
Right. I am giving the copy of the
Yes.
Hopefully, my lord, there is no new document this time, my lord. Again, my lord.
This is it.
registration
Yes.
certificate.
What is this application for? Addition of party.
Additional part. My lord,
My lord,
lordship will kindly give it next week, my lord, because my lord, we have to also go through this, my lord, as well. Because today only we are getting this in.
Okay, on the prayer of learned advocate for the plaintiff, the matter stands adjourned till
Next Monday or Tuesday, or whatever.
okay, 18/6/2025.
Item number 10.
Item number 10, pass over.
Item number 11.
Pass over.
Mr. Raghu.
Yes. Call the adjourn motion.
Item number 6.
My lord, I am very happy for one of the party. My lord, this is an application for substitution. My lord, deletion of
This is
name of
item number
6. My lord, pass over.
6.
Yes, my lord.
Yes.
My lord, this is G115. My lord, this is an application for deletion of one of the defendant. My lord, who died. My lord, without living. My lord, his legal.
You are for?
I am for the defendant number 3A. My lord, 3I. My lord. Mr. Meghnath Dotto. My lord, his brother. My lord. The principal defendant, my lord, 3 has died, my lord. Subsequently, my lord, thereafter, my lord, amendment was carried out, my lord.
No, the defendant number 3, that is Priya Datto.
My lord, Priya Datto, my lord, there is a principal defendant, my lord. My lord,
Yes.
that defendant, my lord, died, my lord. Thereafter, substitution application was filed, my lord. Her legally has brought on it into the record. Now this is an application for deletion of the name of Indrajit Datto, defendant number 3.
So, is this Priya Datto the mother of advocate Meghnath Datto?
Yes, my lord.
Yes. Then I should not take up this matter. She was my client at one point of time, as well as I think I've dealt with these matters, similar matters. So this defendant number 3, deceased defendant is the mother of the advocate Meghnath Datto,
Yes,
member of the bar library. Yes, record and order. This matter is released from this list due to personal reasons.
Item number 10.
Item 7. Yes, 10 pass over. Yes, not today.
Item number 11.
Not today.
Item number 12.
12. Yes, 12. Yes, pass over.
Item number 13.
My lord, I am appearing at number 13, my lord. I am for the petitioner, my lord. This is a probate application, my lord, which has become a contested application. But in the midst of this or everything, my lord, the probate application was dismissed for default, along with the intervention application of one of the defendants, my lord. I am
You are-
for the, my lord, the executor, my lord.
You are for the
Probate applicant. Yes,
Yes.
my lord. So, my lord, basically, my lord, since it has been converted into a contested proceeding, my lord, I will have to bring in my witness, my lord. So, if your lordship can kindly fix any date after the 20th of June, so that, my lord, my witness can be before your lordship and we can proceed with the matter, my lord.
You are for?
My lord, I am with
Okay.
Mr. Rai.
Record and order. Mr. Rai, learned advocate for the petitioner executor, is present. It is submitted that time be granted to bring the witness for examination. Thus, this case stands adjourned till 24/6/2025 at 3 p.m.
My lord, very, very grateful, my lord. Very grateful, my lord.
Item number 14.
May I please your lordship? This is, my lord, arising out of probate proceeding. The matter has become contentious. Other side appeared, but
You are for petitioner?
petition.
Yes.
Now, my lord.
Now, what is GA1 for?
Yes, during pendency, the sole executor beneficiary expired. So this is the application for substitution as well as for amendment.
Oh, actually, you see, if the executor has expired, if there are, then you see, you have to convert the case into a later LA case.
LA case. Beneficiaries are surviving. His widow and son.
So this is the contentious.
Contentious. Other side appeared once. Thereafter did not appear. Last occasion, the direction was made to paper publication. That has been done. Your lordship kindly.
No, who is representing the opposite parties?
Yes.
Opposite party is being represented.
Representing opposite party representing.
No,
But
so
at the time of hearing of this GA, did not appear.
you have served copy of
yes,
the GA.
I served copy, but did not appear.
So let
That
it
is-
appear day after tomorrow. Just serve one more notice. If they don't appear,
No, my lord, the paper publication done.
No,
As per the
no.
direction of the court.
Yes.
Yes. For this particular GA only.
Oh, this.
Yes.
So thereafter it is appearing.
Yes. Thereafter it is happening. One English and one Bengali daily has been published.
You have annexed that also.
Yes, yes. That is there. That has been affirmed on 28th of March 2025.
28th of. Yes, where is that affidavit of service
That is
regarding
there,
publication?
That has been filed in the department. This is my brief copy is there.
No, that affidavit of service regarding publication
Has been filed. Has been filed in the department.
That affidavit of service.
yes.
So let it be put up on the next day.
Lordship. Let it be taken up day after tomorrow because tomorrow is some difficulty. I have some.
Let the affidavit of service filed by the petitioner regarding paper publication be put up on 11/6/2025.
Lord, the affidavit dated 28th of March 2025. Can you mention this?
Dated 28th of March 2025. Filed by the petitioner regarding paper publication. Be put up.
Great.
Lordship, item number 15, I am for the petitioner.
Yes.
I am led by Mr. Sipshankar Banerjee.
Which item? Yes, call the list.
Pass over matter, adjourn motion, item number 12.
Yes, not today. Next.
For hearing, item number 15.
I'm only trying to spot Passover. I'm led by Mr. Sips. He's on his
15. This application is your application, GS6.
On behalf of Mr. Shipshankar Banerjee, he's on his leg at another court, my lord. Short Passover, paying for short Passover.
Let it be not today.
Day after tomorrow, my lord. Tomorrow is.
Okay. On the prayer of learned advocates, let this matter appear on 11/6/2025.
No.
11th.
Any time fixed, my lord?
No, normal time.
Makes it in its position, my lord.
Yes, it will retain its position.
Restoration application, item number 16.
This was dismissed for default.
No copy has been served.
Your Lordship, I am also appearing on behalf of the defendant, Your Lordship. On last occasion, my Lord, I believe that was in the month of December 2024. Your Lordship has given a direction, Your Lordship, to exchange the affidavits, Your Lordship, and to serve the copy
Let
of
me
the,
see the order.
Yes.
Where is that order?
Your Lordship, 12 December
12
2024.
December. Yes, let me see the order. Yes, opposition has been filed by you.
Your Lordship, no copy has been served upon us, Your Lordship.
How
It's
is
been
that?
6
Without
months,
your
Your
not
Lordship,
served?
nothing has been served.
Oh. Kindly
It's
keep
been 6 months, Your Lordship. Your Lordship, to beseech Your Lordship, I may indicate the order, Your Lordship.
Whether the suit your lordship will kindly consider it is of 1960.
No, question is I am considering the restoration application.
Restoration, yes.
So restoration application, copy is not served.
Not
So
served, Your
why,
Lordship.
why
Sorry,
did
my
you
lord.
come-
Your Lordship.
2-3 days time, my lord.
Yes, record an order.
2 দিনে পারবে তো? 2 days time will be enough. Simple matter, my lord. I am requesting, my lord, the authority to look into the matter. I can.
No, restoration.
Yes, yes.
The suit is dismissed.
No, suit is not dismissed.
Your Lordship, one GA20 was filed.
Filed.
That got
That was an-
dismissed for default, Your Lordship. On several occasions, they did
That
not.
has to be restored.
Yes, that was.
So file in the usual way. Serve by. I think it is to be by notice of motion.
Yes, correct.
So file
Lordship,
it.
GA20 was also not served upon us.
No,
Your Lordship.
no.
একসঙ্গে দিয়ে
Let us come to the main now. Now I have taken up this GA21. So let it by the usual process, by notice of motion.
করে দাও।
It has to be by notice of
Yes.
motion. So you have not filed that notice of motion.
He has done, my lord, perhaps his clerk has not complied the.
So it has become
instruction.
defective. I think it's better you withdraw and file afresh.
No. By complying formality, it has been filed, but my lord, only notices are not been given.
No. You see, applications are to be moved by notice of motion. I think that is the procedure. All applications are to be moved by notice of motion. If that is not here, there is no application before this court. So it's better I'm granting you the liberty to withdraw it.
My lord, grant us liberty to serve them and my lord fixed on any day.
No, you see, how can you serve them? You have to come with that, with the notice of motion.
My lord, already matter is, my lord, small, my lord, I have got
Well,
a
it's
soft.
been 6 months, my Lord. The order was passed. They have not served. Now they are saying, my Lord.
Not a small matter, my lord. I have got a soft room.
It is absolutely correct.
I want, my lord, only the whitewashing.
Without notice of motion, there is no
See, there is
application.
without notice of motion, that's a defect. How can I? How,
As your lordship, thank you.
Notice of
Yes.
motion is served on all the
that
defendants.
is file in the usual process, it will be taken up. Oh, this is the notice of motion.
My lord, I don't
21,
think-
GA21. Yes, it is there.
my lord, there are so many defendants.
No, whatever it is. You have not received a copy.
Yes, we are serving a copy, my lord.
But they have not served.
They
in
have
spite
not
of
served.
Direction to that effect in December.
December 12th.
Rose বলছি তোমাদের। My lord, the issue is very simple. I want whitewashing inside my room.
Okay, this is GA21.
Yes. I will serve, my lord. In course of within 2 days.
Yes. Learned advocate for the petitioner is present. Let
Well, we are applicant, you know.
learned advocate for the applicant. Applicant for
Application.
intervener.
Yes.
Learned advocate for the applicant intervener is present. As copy of this application is not served, as the let the
My lord,
same be served.
I am one of the defendants. There are so many tenants. I am one
Anyway,
of the
applicant.
Yes, applicant.
The learned advocate for the applicant in GA 21 of 2024 is present. As the application is not served, let the same be served and let it appear on 17/6/2025. Affidavits, if any, may be filed in the meantime.
Subject to their sending copy within course of the day.
No, I have directed them to serve. It will appear on 17/6. Okay. Affidavits must be filed in the meantime.
Your copy of the application, my lord.
He will file. He will give it to you.
Your lordship, there was a time, your lordship, I bow down to your lordship, there was a time was given your lordship within 2 weeks. Your lordship, in the meantime, we will file the opposition.
Okay, the copy be served within 24 hours.
Yes. Xerox করে দিয়ে দাও। Oh, we are serving, my lord. Within 2-3 hours আমরা দিয়ে দিচ্ছি। So 17th. Because
Your lordship-
in this side, my lord, we are not so, I am not so accustomed. He is regularly doing.
So it takes time to get ourselves accustomed.
So I am requesting it, you do the formality.
All of us require time to get ourselves accustomed.
Yes.
My lord,
No, in the original side, my lord, we are
Yes.
not.
my lord, the time to file affidavit and opposition, my lord, we will file the opposition.
Restoration, what happened? It was suddenly
You see,
appeared.
this is not affecting the merits of the case. 3-4 days is sufficient.
Lordship, I am not on that. I am lordship saying that we will file the affidavit and opposition in the meantime, my lord. Kindly grants me 2 weeks time, my lord.
No, I have kept it on 17th. Why 2 weeks time?
17.
1/7.
Once.
He file it in the meantime.
I am extremely grateful.
Lordship's pleasure also to direct them to serve the main petition because unless.
No. First restoration application.
For framing of issues, item number 17.
Lordship, item number 17, I'm appearing on behalf of the plaintiffs. My lord, on the last occasion, your lordship had said to complete the
For defendant number
recovery and inspection in the meantime and frame the issues. But however, my lord, when we contacted the plaintiffs, the plaintiff number 1, my lord, has.
You are for the plaintiff.
Yes, my lord. So the plaintiff number 1, my lord, who has most of the original documents as referred to in the plaint, my lord, is not in the country, your lordship.
Let me see the order, last order.
So, my lord, anytime after the second week of July, if she was praying, she's going to come back. Further, lordship, if I humbly submit, there is one application being J16 of 2023, which is pending, and I'm enjoying an interim order. That was supposed to come up on the 30th of April. Lordship, on 23rd of June.
May 2024. So last order was passed on 7th May 2024
Lordship, April.
by Justice Mojumdar.
No, my lord, lordship had passed an order on 23rd of April 2025. Just a second.
No. This is which suit of which year? 2006.
2006.
2006, your lordship.
So this court does.
In April,
2006 to
your
anyway,
lordship
this
had
was
heard the matter.
It was passed by Justice Mojumdar.
Your lordship had extended the interim order in April.
By an order dated 24th April, your lordship extended the interim order, my lord.
Last order.
দেখি অর্ডারটা এপ্রিলের কত তারিখের অর্ডার বলছে you have a copy of that order?
Yes, my lord. My lord, I'm sharing it. If I may just hand in my iPad to your lordship. This is the last order.
Yes, record an order.
Lordship, on the second week of July, the plaintiff number 1 is returning to India.
Learned advocate for the plaintiff.
She has
and
the
learned
original.
advocate for defendant number 1 are
I'm
present.
only for defendant 1.
In terms of the order dated 24th April 2025, the parties could not complete their discovery and inspection as because the plaintiff number 1 is out of station.
Out of the country, my lord.
Out of station. Stop. The Parties are granted liberty to complete the discovery and inspection within a period of 8 weeks. Let this matter appear on. Okay, you complete it within a period of 6 weeks.
Yes, yes, Your Lordship. Second week of July, we can get it done.
Let this matter appear on. (24/7/2025). The interim order granted earlier in GA 16 of 2023 stands extended for a period of 8 weeks or till further orders, whichever is earlier.
Grateful.
Grateful, ma'am.
Witness action, item number 18.
My lord, this matter is a testamentary matter, contested one. My lord, I appear for the executors. My lord, the defendant's witness is in the box.
Yes, Lordship, I think this matter is appearing today by mistake. My learned friend had mentioned this matter on 19th of May.
When it is due to appear.
Yes, I will tell. So my learned friend had mentioned this matter on 19th of May, when your lordship said that it will appear 1 week after vacation for as to be mentioned, for the date to be fixed for the witness
my
action.
lord
But it
will-
has appeared today. My
my lord
witness is not here today.
My lord, will kindly fix a date.
Yes, lordship can kindly fix a date any
Yes, Reconnaissance.
2 weeks.
On the prayer of learned advocates, the matter stands adjourned till 25,
25th
okay,
June.
23,
23rd June.
6, 2025 at 3 p.m.
23rd.
23rd June at 3 p.m.
At 3.
For witness action.
Yes,
I'm grateful.
All suits, item number 19.
2 p.m. 2.
Item number 20.
Yes, Passover.
Item number 21.
Yes, record and order. 21.
21. I am for the petitioner in this matter. Your lordship will recall this is a decree where there was an appeal. Appeal has been dismissed. They were put on conditional stay. Conditional stay not.
So why were you not appearing all from the last occasions? It is made as a last chance. 21, item 21.
21.
Yes, Your Lordship.
Because probably it was appearing for 2-3 occasions, and I had to made it as the last chance.
Well, for them, they were supposed to get a recalling because their appeal was dismissed.
Yes.
Your
They
Lordship,
were supposed to make an application for restoration.
Probably none appeared on the last.
No. She appeared.
we appear, Your Lordship. Your Lordship, we have filed a restoration application.
There
That
no
is
detail.
pending adjudication, Your Lordship. We have served it upon them as well. Your Lordship, they have received it.
Oh.
It is
Which application is to be taken up today.
Today is the execution application. I am saying there is no stay. They were supposed to bring a stay by today. Appeal
Your Lordship, it is
dismissed, stay-
listed, Your Lordship.
Let
it's
me see the
listed.
order.
Conditional stay never complied with. Appeal dismissed long back. I am entitled to execute the decree. Your lordship has given them 3 chances. They have
Your
not
Lordship, the
been able to
listing date is on 12th June, Your Lordship, before the division bench, Your Lordship,
Might
of
be
the
that is
restoration
not done.
application.
You should have got a stay by today.
Your Lordship, we have already filed the restoration application and it is due to appear on the 11th of.
Is there any interim order when the appeal
No,
was
that-
pending?
Your Lordship, at the
Second day.
beginning, there was an interim order when they did not appear. They chose not to appear, I would rather say. Now they have come, they have then applied and it's got the order vacated. It was dismissed for default. Now we have filed a restoration application. It has been served upon them.
But the conditional stay of putting in 10 lakhs has not been complied by them. So
Very
no
well.
interim order from the
But
beginning.
Your Lordship, we have filed the restoration
No
application.
interim order in the stay.
If there is no interim order, the execution case can proceed.
Yes, that's what we are
Very
saying.
well, but Your Lordship.
But it is not a question of interim order. There is no appeal also.
No appeal also today.
No, yes, Your Lordship, but we have filed such an application
That is
in
not
time,
enough.
within limitation, and it is due to appear on the 11th, and it has already been served upon them.
Maybe served. You should have got it. You could have mentioned it even last day of the court. Got it listed.
13th May, okay.
Yes.
13th May,
Yes, we
Plenty prayed for time.
yes.
This is recorded.
Yes, we had prayed for time because we did not file an restoration application by that time, which is why we prayed for time that we will file the restoration application within the limitation, and we had filed it within the limitation without any delay. It's not that we have not taken any step.
Yes, is it going to appear on 12th?
It is going to appear on 11th, Your Lordship.
I do not know.
So from where do I get that? Any order?
Your Lordship, we had filed it and we have assigned the date 12.
But
It will appear.
April, the appeal has been dismissed. Today we are in June.
Your Lordship,
They have not cared to either
Your
make a
Lordship, on the
application or to get a stay.
But copy of the restoration.
Copy has been now.
on the last occasion, it was not filed when it appeared before Your Lordship. Thereafter, we had filed it.
Today, my learned friend has no stay, no appeal. Kindly,
No,
my lord,
when did
allow
you
me-
file the application for restoration?
We had filed it within the 30-day time limitation. We had after the 13th May, Your Lordship, because by 13th May we did not file, which is why we prayed for time to take necessary steps, and we had duly taken necessary steps. It's not that we are sitting tight.
How can the court know that it is fixed on 12th?
Your Lordship, we can always show. Okay, status
Show it to your learned friend.
Very well, Your Lordship. I'll
But
just
that does not
April,
prevent the taking of
April,
the
the appeal is dismissed. Before that also, they did not have any protection in the appeal because the conditional state they did not comply. Today, my lord, in June, they say, oh, June 12th, the matter will appear. Why?
Wait, today is the first day. Let them get some.
Yes, Your
concession.
Lordship.
Let it be fixed tomorrow. Tomorrow will not be the
Tomorrow.
On the first
Let
day,
the
some
first-
concession should be.
My learned friend, let him get some breathing time today. Let him mention
Kindly-
for the appeal court.
Yes, absolutely.
Kindly fixes it day after tomorrow. Let them mention
Your
it before the
Lordship,
appeal court.
the appellate bench only, this is a specially assigned matter. The appellate bench only takes up original side on certain days, and it will appear on the very next day. The Honorable Division Bench will take up original side matters, which is day after tomorrow.
Yes, record an order.
Fixes it on Friday, my lord.
Learned
2 days later.
advocate for the defendant petitioner and learned advocate for the opposite party plaintiff are present. Although today is fixed as the last chance, but the learned advocate for the
Your Lordship, today is not.
I have made it.
It's fixed on 10th as the last chance, and today is not the last chance.
It is not. It is due to appear tomorrow. So tomorrow you can bring necessary orders.
Yes, let him.
Your Lordship, if it's a specially assigned matter, Your Lordship kindly.
Although the matter is due to appear on 10/6/2025 as the last chance, but the matter is appearing today by on the submissions of the learned advocates. The matter
is taken up.
Is fixed on
the 12th.
The matter be fixed on 18/6/2025 as the last chance for obtaining necessary orders from the appeal court. Stop. It is hereby clarified that no further adjournments will be granted.
Without
Your
an order of stay, my lord, kindly mention.
Your
that.
Lordship.
If
Further adjournments
Your
will be
Lordship.
granted.
say, my lord, this is
Your
still
Lordship.
pending. Let it be clarified without an order of stay from the appeal court.
No
Your
further
Lordship
adjournments
kindly.
will be granted without any specific
My
order
lord.
from the
Your
learned
Lordship
advocate.
kindly extends the time to file the affidavit in opposition.
Yes. Extend.
The time to file the affidavit in opposition. Your Lordship kindly sees the order of 13th May.
So there is no bar in filing affidavit in opposition.
That he will come and renew his prayer. Let him
See,
first get a stay.
There is no such bar. Anytime you can file it.
Then Your Lordship,
Because there is no
I
stay of
can only
proceeding.
file it after the next occasion when Your Lordship grants the extension.
See,
Let him first secure a stay.
No,
from
but
the
if
appeal
my
court.
learned senior friend is suggesting that it will be filed after the extension on the next occasion, then very well, let it be recorded.
I am not
You
suggesting
see,
anything to
there
it.
is no bar in filing affidavit in opposition because there is no stay of further
Then
proceeding.
Your Lordship kindly extends the affidavit in
Okay,
opposition.
let affidavit in opposition be filed by the next date fixed. No,
Great.
you file it within 5 days. He has to file the reply.
Kindly gives me some time.
Any reply.
Okay,
him
let
file it by
affidavit in
18th.
opposition be filed by the next date fixed.
Great.
Good for it.
Item number 22. 18.
Item 22, I appear on behalf of the plaintiff.
I appear for the defendant.
Your lordship will take the last order passed by your lordship, which is 5th May 2025. Your lordship has given us liberty to take instruction with regard to discovery and inspection. I'll tell your lordship why instruction was required. Because we had verbally submitted that many of the documents for the purpose of discovery and inspection were destroyed by an act of fire at the plaintiff club. So that is why we wanted an instruction from the client to take out an application for reconstruction of documents. Now, your lordship, we have taken out an application. It is affirmed and ready. It is before me. Now, the problem is, as per the notice of motion, I have to serve the defendants first.
Yes.
Before filing. Now, while
I am adjourning the matter, you take necessary steps in the
your
meantime.
lordship, I'll indicate to your lordship, one minute, I'll take your lordships. Defendant numbers 1 to 4, as per the registrar's report, we have obtained a report dated 28th March 2025, has been represented by one Shobboshachi Sen advocate, as per the latest record from the registrar. So when we went to serve the notice of motion to him, he had verbally refused, saying that he is no more related to
we have been representing this defendant, and my learned friend is also appearing for me last 2-3 years.
You are representing whom?
The defendant, my lord. There is a change of advocate. My learned friend has now.
I understand. I'm not
my learned
what
friend's my lord, advocate on record is well aware. There are communication from our end.
Submit.
Today, my lord, this
Kindly let me
submission is
submit.
being made that
Why
we have
this
went to
submission is being
state-
made, I'll indicate to your lordship. When we checked whether there was a changed wakalatnama, we could not find. Now, as per the original side rules, they are not to represent themselves unless they are supported by or instructed by an advocate who has duly filed a wakalatnama. Your lordship will take order 1
must
rule
be
5.
filed, otherwise how they are appearing in court?
But as per the
No,
registrar's report,
unless you have filed the Vokalatnama, how can you appear in
difficult
court?
time indicating.
have, my lord, my lord, as my learned instruction is, my lord, he has filed a wakalatnama upon obtaining.
Vokalatnama, they cannot appear
And
in
my lord,
court.
absolutely, I bow down, lordship.
5 to 6 years we are opposing this application. And there is several communication.
From my learned.
No, maybe what the practical difficulty we are facing while serving is that
straightway serve it to us.
Advocate on record is very much
Just
aware.
no, as per March of 2025, the record is that Shobboshachi sent. This is by your lordship's officer.
Anyway, if they have served you a communication, they have taken the responsibility.
No, I understand, but as per the rules, any communication.
Let him follow advocate on record instruction.
We were also,
If
my
the
instruction
other
is,
side, if the former advocate has refused, and if you have received a communication, then you serve it. It is their responsibility.
I understand, but as per the rules, there ought to be a
Anyway,
wakalatnama in the department.
Otherwise, you have to serve the defendant if you want to do that.
Yes, yes, we'll do that.
Submission with your lordship. Let him ask what is the instruction of his advocate on record.
Anyway, yes, record and order.
We'll personally
Learned
serve
advocate
the
for the
defendant. That's
plaintiff
no difficult.
and learned advocate for defendant number
1 to 4.
1 to
1.
1
Yes.
to 4.
1 to 4 are present.
All defendants.
As the learned advocate has disputed as to who is the learned advocate on record appearing for the defendants, let service be caused upon the defendants personally.
Yes.
Let this matter appear on 18/6/2025. So let him serve directly the defendants.
Great. Grateful, lordship.
Item number 23.
Yes, 23. Pass over.
Item number 24.
In item 24, we are representing the petitioner. My lord, in this matter, we are praying for 2 weeks adjournment. My lord, petitioner is suffering from serious illness. That's why.
Petitioner plaintiff.
Plaintiff.
Yes, record and order. On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 23/6/2025.
Obliged, my lord.
Item number 25.
My lord, will recollect, lordship, I was appearing for the plaintiff in this matter. Lordship, on last occasion, I sought your lordship's leave, my lord, to take instructions. My lord, I have not been getting instructions. In fact, my lord, I had written a letter to my client, my lord. Surprisingly, my lord, the letter which was sent, my lord, has come back. Envelope has come back saying that no such addressee. So, my lord, I was humbly beseeching your lordships, my lord, lordships, kind leave to permit me to retire from the matter, my lord. Lordships can see, my lord, the originals are here only if my lords want to see it.
It's a limited company.
My lord, limited. My lord will kindly see the last envelope. Came back. Back side of the envelope, lordships will see. Lord, I cannot do anything beyond this now, Lord.
Addressee cannot be located.
Cannot be located. Lord, now there is no way, my lord, I can try to locate the client, my lord. That is the address. Lordships can compare it, my lord. That's the address in the cost title.
Address one administrative notice can be sent.
Lord, that, my lord, that is for lordships to direct the department. At least lordships can permit me to retire from the matter, my lord.
Yes. Learned advocate for the plaintiff. The Mr. Jain, learned advocate for the plaintiff, is present and submits that he has no instructions to appear in this matter. It is further submitted that by letter dated May 15, 2025, he intimated the plaintiff regarding the suit and the notice has returned that addressee cannot be located. Stop. The learned advocate prays leave to retire from this matter. Stop. In the facts and circumstances, leave is granted to the learned advocate to retire from the matter. However, in the interest of justice, let an administrative notice be issued upon the plaintiff. Let the matter appear on 23/7/2025 for report.
Would it be my lord's pleasure, my lord, to record a copy
Let
of
the
letter?
communication given by learned advocate of the plaintiff to the plaintiff be kept with the record.
Lordships are retaining the originals with the records.
The letter be kept with the record. You have your copy with you?
My lord, I have handed over both, my lord.
Okay,
Copies.
okay. Then you take back.
I'll take back the copy, my lord. Original may be retained, my lord. Grateful, lordships.
Item number 26.
Please, my lord. My lord, I appeal to the plaintiff number 3, my lord. My lord will kindly take up the last order passed by my lord in this matter. My lord, on the last occasion, I had submitted before your lordship that, my lord, the defendants have been served. My lord, the report, the service report I had also placed, and your lordship had recorded that the defendants have received a copy of the writ of summons along with a copy of the amended plaint. My lord, your lordship had directed me to ascertain from the department whether the defendants have filed the written statements and or whether they have entered appearance. My lord, I have ascertained only the defendant number 1 has entered appearance and filed its written statement. My lord, the rest of the defendants 2 to 7 have neither entered appearance nor filed written statement.
So, okay. Only defendant number 1 has entered appearance.
Yes, my lord. May I hand over the
He is represented also.
represented, but my lord, not appearing for the past several occasions. My lord, may I hand over the report, my lord?
Yes.
Copy these. Copy these.
Defendant number one has appeared and filed written statement.
Filed written statement. But my lord, this was way back in 2013. My lord, over the past several occasions, the defendant number one has not been appearing. In fact, my lord, on 14th May of this year, my lord, I had sent a notice to the defendant number one seeking inspection of certain documents. My lord, they've received a copy. The learned advocate for the defendant number one has received a copy. But my lord, I have received no communication in respect of this letter also. My lord, may I hand over this letter as well? My lord, this was a communication by us, the plaintiff number three, to the learned advocate of the defendant number
Still there.
one. Yes, my lord. The learned advocate is there, has accepted the notice.
So let me record the status of with regard to other defendants. It will proceed ex parte.
Yes, my lord. I would be praying that they be.
So far, except defendant number one.
Except defendant number one, the suit be proceeded as undefended against the rest of
So far, defendant number one is concerned, as because he is represented by one learned advocate, and you are ready to give inspection of the documents.
Yes, my lord.
So you can take one more chance and let it appear after 2 weeks.
Grateful, my lord.
Yes. Learned advocate for the plaintiff number three is present. Learned advocate for the plaintiff number three furnishes a report issued by the Deputy Registrar Legal stating that only defendant number one has entered appearance. However, the defendant number 2 to 7 have not entered appearance. But service is complete.
Service is complete. My lord, your lordship in the last order had recorded this. My lord,
Although service is complete. Thus, the suit to proceed ex parte against defendant number 2 to 7. Learned advocate for the plaintiff is granted one more, is requested to serve one more notice upon the learned advocate for the defendant number one for causing necessary inspection. Let this matter appear on 24/6.
Grateful, my lord.
So you serve one more notice for the inspection and let it appear on 24/6.
Grateful, my lord. We shall do that.
Because it is written statement is already filed. Issues are to be framed.
Original to the
Item number 27.
In item 27 also, I am facing the same predicament as in item 25. Lordship, same thing happened. Your Lordships, please to pass similar orders in item 25, my lord. In fact, my lord, both 27 and 28.
This is 27.
This is 27, my lord. Here, my lord, it says that the addressee cannot be located. The postal endorsement.
This case 28.
28, my lord.
No, this is item.
This is 27.
This is 27.
Item 20, no such company in this address. The postal endorsement says no such company in this address.
Same as 25.
Same as 25, my lord.
আচ্ছা 25 এর অর্ডারটা যেটা আছে সেটা করে দেবেন। Yes.
Letter dated is same. Same. Letter date is same order.
Same advocate, everything same. তাহলে ওই 25 এ যে অর্ডারটা পাস হয়েছে ওটাই করে দেবেন আর সেম ডেট থাকবে। The original will be with the record. You take back the copy.
I have kept the copy with me.
Yes.
My lord, it's same in 28 as well, my lord.
28. Let me see.
Did. Joseph.
May 15.
May 15 again, my lord.
Same. It cannot be traced out.
Cannot be traced out. Cannot be located.
Yes, same order. একই order করতে হবে।
Pass over matters, item number 20.
Yes, not today.
Item number 23.
Not today. হয়ে গেছে?
আচ্ছা 2 PM টা শুধু ফিক্সড আছে।
My lord,
Mentioning.
yes, my lord, under compelling circumstances, I'm mentioning this matter today, my lord. Client, my lord, defendant number one possibly came and served me. What I find from the order dated 24th April 2025, Lordship has appointed me receiver in this matter. But, my lord, I appeared in this matter. In my early days in the profession, I got a brief and I assisted Mr. Shujit Addi in this matter.
Anyway, so let it appear as to
Yes,
be
but
mentioned.
I just thought, my lord, I should point out to your lordship because the
long
order.
time ago, a month of
Yes,
April.
but today the client, he came and
You
he
had
said
not communicated with the
nothing.
order.
Today he came. Today he came, no letter, but I thought, my lord, I should point out to the
Anyway,
court.
so
No, today I'm not saying anything. Kindly, my lord, consider my prayer. I may not be able to come on that day. And kindly, my lord, discharge me because I thought it's my duty, since lordship has appointed me as an officer of the court, to point out this fact. Otherwise, already there is 1 month, my lord. 24th April, today I got the order. 2 months in almost.
anyway, so let it appear.
Very well, very well. I am
Give
told.
that, give that. I shall
Yes.
remember. Day after tomorrow, it
Lord,
will appear.
11th of June matter is due to appear. So on that day, lordship can
Yes,
pass
yes.
necessary orders.
Yes, give that.
Lord, I am handing over to your lordship. I'm sorry for troubling you, Lord. Grateful.
11 তারিখে থাকবে।
11 তারিখ। Grateful.
Whole source fixed at 2 p.m. Item number 19.
Milord, I'm opposing this application. I will be humble prayer, Milord, subject to what my lord thinks. Mr. Kaur would be taking some time, so let him make his submissions today, Milord. I shall come back on another day if you so just let him start. That this is not a suit for eviction of a tenant, a lessee. Not the property is premises number 34 Jackson Lane, Kolkata. Yes, Lord, 34 Jackson Lane, Kolkata. Area is 1 bigger 2 kathas. Now, Lord, there was a deed of lease executed on 4th of February 1983 for 49 years, commencing from 1st April 1980. Look, the suit was filed upon termination of the lease by a notice dated 26th of July 1985. There were 2 grounds. One is non-payment of rent. And number 2 is breach of covenant as to construction. The lessee was supposed to demolish the property and make a multi-story building. Now, when the suit was filed, 2 orders were passed in the suit at the interlocutory stage. The first order, if your lordships kindly come to page 49. G9. G9 to the okay. Page 49, if your lordships kindly take. This is an order dated 22nd May 2003. 49A is the type copy. If your lordships kindly turn to page 49A, this is the type copy. Yes. Says in view of the discussions and in terms of the negotiation between the parties,
the matter is treated as on the day's list and the following order is passed. It is directed that the defendant applicant, Andrew Yule and Company Limited, after demolition of the existing structures on demise premises, being 34 Indra Kumar Karnani Street, Kolkata 7,01,000, shall start the new construction on demise premises within 2 years from the date of this order, and shall complete the construction on the said demise premises up to optimum height permissible for the construction of a new building, according to the plan sanctioned by the Kolkata Municipal Corporation within the extended time of 5 years from the date of this order, and the Xerox copy of the said sanction plan duly attested will be handed over by the defendant company to the plaintiff. Then kindly will turn the page. Kindly come to the third paragraph at page 58. It is further directed that the defendant shall pay monthly occupation charges of rupees 1 lakh per English calendar month in place and the present rate of occupation charges of 33,000 per month from the month of April 2002 to 31st March 2008. It is further directed that the company shall pay the area occupation charges from the month of April 2002 to 31st March 2003 at the rate of rupees 1 lakh only, less the amount already paid within 8 weeks from the date of this order. Then it is further directed that the defendant company, lessee, pay to the plaintiff's lessor monthly rent of rupees 3 lakhs only per English calendar month with effect from 1st April 2008, and there will be increment of 10% of the said monthly rent every 6 years until the expiry of the lease. The extent of the increment in occupation charges rent as ordered in clause 1, subclause 6 of the lease deed dated 4th February 1983 shall stand modified accordingly. Apart from the payment of rates and taxes and other taxes referred to in the said deed of lease, the lessee shall also pay all other taxes, including the water tax and fees, or any other impost, it should be impost, that may be levied in respect of the demise premises by Kolkata Municipal Corporation or any other authority from time to time. Certificate of paid up rate bills from Kolkata Municipal Corporation confirming that there is no outstanding dues on account of any tax in respect of the aforesaid premises shall be furnished by the defendant company to joint receivers within a period of 8 weeks from the date hereof. Now, Lord, I'll just pause for a moment. Joint receivers are the Shebites. So it's a litis property. The Shebites have been appointed as the joint receivers. From time to time, the Shebites, Lord, whoever died, Lord, was replaced by another Shebite. So, Lord, it is the Shebites who are the joint receivers. Now, Lord, please come to the last paragraph. It is further directed that if the defendant applicant fails to start the construction of the demise premises within 2 years from date of this order, then after 49 years, that is initial period of lease, there shall be no option by the lessee for renewal for a further period of 19 years as contemplated in the original lease deed. In this respect, the operative part of the said lease deed containing the option clause shall stand modified. Then Lord 52A, kindly take the first paragraph. It is further directed that if defendant applicant fails to comply with any part of the order herein before made, the defense of the defendant company shall be struck out, and the suit which stands adjourned for 5 years from the date hereof will be transferred to the list of undefended suits for obtaining an ex parte decree. Then, Lord, there are other directions that may not be relevant for our purpose. Lord, the issue today is in this application, I am seeking, Lord, a direction on the defendant to deposit, Lord, occupation charges, which they have not been paying.
That means, according to you, this order has not been complied with.
This order was complied with till a particular date before around the COVID period. After that, it has not been complied with. This is, Lord, my implementation. There is another order.
Okay, order complied with up to a particular period.
Then, Lord, there is a default. Today, this application is only, Lord, for direction on the defendant to deposit the rent. Now, Lord, post this order dated 22nd May 2003, there was a further order because Lord, the defendant Lord failed to comply with that order of 22nd May 2003. So Lord, the parties again Lord filed a terms of settlement before the court, again at the interlocutory stage. If your lordships Lord kindly come to page no. Kindly come to page 64. I'm sorry. Oh no, sorry. I'm sorry. Lord, please see the order at page 55. See the order at page 55. May 2009. It said, by the agreed terms filed in GA number such and such is disposed of, the said order is passed for the benefit of the Devottor estate.
So that was disposed of.
The GA.
And in terms of the
settlement. Now, Lord, the settlement was incorporated in the supplemental deed of lease. Instead of Lord putting the settlement on record, we have put the supplemental deed of lease, which the parties had executed based on the settlement. And that Lord quotes the order also. The supplemental deed of settlement at supplemental deed of lease starts at page 57. Your lordships will straight away come to page 64. Page 64. Yes. Yes, 57.
In a page 6.
In a page 5 first, if your lordships will kindly come to 63 there. It should be 63.
Yes.
Kindly see Lord the second paragraph. And whereas due to further various reasons, the complete demolition of the existing building and construction of the new building at the demise premises could not be done by the lessee. Has your lordship got that? Made another application being GA number such and such in the said CS for further extension of time, and upon consideration of the said application, the Honorable Justice so and so was pleased to further extend the time for completion of demolition of the existing structure at the demise premises within 4 months from the date of the order, and the time for construction of a new building up to the optimum height permissible under the Kolkata Municipal Corporation rules and regulations ready for use and occupation was further extended for 5 years from the date of the said order, with fresh directions in regard to monthly occupation charges, rent and other charges, etc. payable by the list. The relevant directions given by the Honorable Court in the said order dated 21st May 2009 are. Now, Lord, this is the terms of settlement is now quoted. Your lordships will find the terms. I will just take your lordship to the relevant terms. Lord, kindly come to page 64. Come to clause 6.
Yes.
It is further ordered that the defendant applicant, has your lordship got that, shall pay monthly occupation charges at the rate of 3.50 lakhs with effect from 1st April 2008 as per English calendar month, in place and present rate of 3 lakhs per month, and shall pay the area occupation charges from 1st April 2008 within 8 weeks from the date of this order. Then 7, it is further ordered that the defendant applicant shall pay to the plaintiff monthly rent of rupees 4 lakhs from 1st April 2013, and thereafter monthly rent shall be increased by 12% every 5 years till the expiry of the lease instead of 10% every 6 years as per the order dated 22nd May 2003.
So till 2020, this was paid.
This till 2020, this was December 2020.
That was during the COVID period.
During the COVID period, they did not pay. There are correspondence to show. I'll place those letters where they said that the COVID period has brought difficulty. We will pay immediately after the COVID period, but they did not. After the COVID period, also no payment was paid. Please come to page 65. Clause 10, your lordships will find that this clause was also retained with regard to striking of defense if there are defaults. Then page 67, my lord will find that there is a lessee's covenant kindly see the clause 1 that itself is sufficient for our purpose. It says that they covenant to pay 3,50,000 only per English calendar month with effect from 1st April 2008 to 31st March 2013 and pay monthly rent 4 lakhs only from 1st April 2013 and thereafter the monthly rent shall be increased at 12% every 5 years till expiry of the lease. So, my lord, what the court did was when they were in default, they were given chance by way of terms of settlement at the interlocutory stage that they should increase the payment of occupation charges, and they accepted that, abided by it, and a supplementary deed of lease was executed. This lease was executed sometimes in 2010, 5th of August 2010. And after that, Lord,
this page, supplementary
deed of lease is page 57. Page 57. I had given your lordship that page. Page 57. Now, Lord, the application, if your lordship kindly sees the summons, now, in the application, the prayer is this is the area, 3 crore 47 lakhs is the area from December 2019. Actually, Lord, they paid till November 2019. Default is from December 2019 till February 2025. And Lord, now with this 12% increase, it has come to 5,92,076 per month. So we are also seeking a direction for payment of this amount.
Yes.
There are other directions, Lord, with regard to payment of service tax, etc., municipal tax. Those are prayer F, your lordships will find. These are all, Lord, part of the
Now
obligation
you are
of the
praying
lease.
for this prayer B and anyway prayer A or B.
A or B.
Or B.
Or alternate, and Lord, I am
Prayer C.
C is an injunction. And also, Lord, prayer F. Because, Lord, we find from the municipal portal that, Lord, the taxes are outstanding. Now, insofar as this matter is concerned, there are few facts, Lord, which I want to highlight. Lord, if your lordship takes note, his affidavit in opposition of Orno Mukherjee.
Affidavit টা দেখি
Orno. এটা account wrong. Can wait a second. Orno Mukherjee, account wrong, second. Has your lordship got the affidavit?
Yes.
Lord, paragraph 3 is the defense.
Yes.
Please come to paragraph Roman 2. 3 paragraph Roman 2. Page 2.
Yes, paragraph 3.
The defendant has filed its written statement in suit number 574 and has denied and disputed the allegations made in the plaint. It is specific averment of the defendant that it had paid rupees 8,50,000 as advance rent to the plaintiff when the suit was instituted. A sum of rupees 2,22,000 was lying in excess rent already deposited with the plaintiff. Therefore, the allegations regarding default of rent as made in the notice dated 26 July 1985 and in the plaint are untrue and incorrect. Now, my lord, this is an issue to be decided in the suit. Obviously, my lord, I am not calling upon your lordships to at all, lord, address this at this juncture. Because all the terms of settlement, the 2 orders that the High Court passed are all subsequent. One is dated 22nd May 2003, the other is dated 21st May 2009. And this is an issue that he has raised with regard to as on the date of filing of the suit in 1985. So, Lord, this is of course not to be decided in the suit. Then, Lord, Roman 3. The parties were in dispute with respect to construction of a building on the demised premises. Pursuant to orders passed by the Honorable Court, the parties entered into a terms of settlement dated 1st July 2009 and subsequently a supplemental deed of lease dated 8th August 2010. This is Lord page 57, which I showed to your lordship, was executed between the parties. The parties had agreed to a timeline within which the defendant had to demolish the existing structure and complete construction of a building on the demised premises. The defendant was allowed to engage any suitable third party to complete such construction and had the contractual right to sublet any part or portion of the constructed building. The parties had also agreed to the rate of rent and its periodic enhancement, which is recorded in the supplemental deed of lease. As a matter of fact, the tenure of tenancy as recorded under the deed of lease and the supplement of deed of lease is subsisting and is due to expire on or about March 31, 2029. If your lordships ultimately hold in the suit that my eviction notice was bad, then Lord, what he says is right. The defendant had engaged Akriti Sales Private Limited, hereinafter referred to as Akriti for brevity, to demolish the existing structure and construct a building thereon, also to pay rent with respect to the demised premises. The terms between the defendant and Akriti are recorded in an agreement dated 12 September 2007, which has been disclosed with the said petition. Like the defendant had the right to sublet, the said Akriti also had the right to sublet any part or portion of the constructed building to third parties. Akriti continued to pay rent, which was of the same quantum charged by the plaintiff from the defendant under the said supplemental deed of lease. Now, Lord, this is where I join issue. Lord, he has introduced a case with regard to a third party to whom he has parted with possession with regard to the property. Now, Lord, 2010 supplemental deed is between my client and the defendant.
So the third party was nowhere involved.
Absolutely nowhere involved. And Lord, there the defendant, Lord, admitted its liability to pay. Not only the liability to pay, the entire liability, there was no whisper with regard to any of this story. This is running contrary to the supplemental deed. I'll just not take your lordship back to the supplemental deed. Then, the plaintiff have been receiving rent from the defendant which was paid by Akriti. This has been continuing on and from September 12, 2007. Now, Lord, the deed of supplementary deed is of 2010. The plaintiffs at all material times were aware that the rent is being paid by Akriti. Lord, even in 2010 supplementary deed, Lord, there is no whisper. The plaintiffs were also aware that Akriti along with sublessees are in actual physical possession of the demised premises. Plaintiff knew that the defendant is neither using nor occupying the demised premises. No part or portion of the rent derived from the said demised premises were ever enjoyed by the defendant. The defendant has not made any profit out of the rent paid for the demised premises. A chart showing payment of rent by Akriti, which was ultimately being received by the plaintiff, are annexed. The plaintiff have admitted in the said petition to the fact that individual entities who are enjoying actual possession of the demised premises must pay occupational charges. The defendant is not in physical possession of the demised premises at least from 12th September 2007. My lord, kindly mark the date. And also take note of the supplemental deed which is dated 5th August 2010. And in 5th August 2010, they admit that they are in possession, they admit their liability to pay rent. Now, Lord, the next sentence is very interesting. The parties always had mutual consent and were ad idem in this mode of payment of rent. Therefore, the alleged claim for arrears of rent against the defendant is misconceived and misdirected. Lord, this reading is itself contrary to Lord page 57. I'll just take your Lordship, Lord, to that document once I place this affidavit. Now, Lord, please come to paragraph 8. It is pertinent to mention that the existing structure on the demised premises was demolished and a new building was constructed thereon, which has been under possession and used by Akriti and its sublessees. The defendant has complied with its obligation to cause construction of a building on the demised premises which is unusable. There is no complaint by the municipal authority against the construction of the building on the demised premises. Therefore, it must be understood that the construction of the building on the demised premises has lawfully been completed. The plaintiffs filed GA 6 of 2022 with prayers which are identical to the prayers made in the said petition. Affidavits were exchanged in GA 6. However, the defendant objected to the hearing of GA 622 on the ground inter alia that the suit was not maintainable because the notice forfeiting the lease had become infructuous pursuant to the orders passed by this honorable court, completion of building, acceptance of rent by the plaintiff and other relevant subsequent events. A copy of the master summons. This was an application which they had taken out. Then, Lord, the defendant took out.
This application was disposed.
No, this application, I'll tell you, Lordship, the matter went up to Supreme Court.
GA 8 of 2023.
No, GA 8. GA 8, sorry.
GA 8 of 2023, not yet disposed.
No, that has been disposed of.
Yes.
GA 8, Lord, was dismissed. Then it went to the division bench. I'll show you.
GA 8 is by the defendant.
By the defendant. They are seeking dismissal of the suit.
So GA 8 was disposed, to which you went to Supreme Court.
No. GA 8 was dismissed.
Yes.
Against which they came to the division bench.
Right.
Division bench held that this issue, whether the suit has lost its force, should be tried by framing an issue as a preliminary issue under Order 14. Now, Lord, the matter travelled to the Supreme Court. I'll show your Lordship the order. The Supreme Court, Lord, sustained the order and said that liberty is given to the parties to file appropriate applications if they want. That means even to my client, the liberty was given to file an application. Lord, my contention is, irrespective of the fact whether the suit survives or doesn't survive, I am, as a landlord, I have a contractual relation with the defendant. I'm entitled to this rental. Whether, Lord,
unless the suit survives, how can you get the interlocutory relief?
I am not asking for the rent to be paid to me. I am saying that during the pendency of the proceedings,
the suit has to survive.
Lord, I am not saying that it should come to me. At least they should pay the rental, deposit the rental to the court.
Yes, that's.
I am not saying that you pay the money to me directly, but at least, Lord, they must honor their obligation. They must deposit the money.
It is subject to the trial of the suit.
Subject to the trial of the suit. Lord, even if I lose my battle of eviction, Lord, I don't lose my property. Property still remains my property, and he will continue to be my sublessee or lessee. He will Lord, at the highest, what will happen? If the suit does not survive, I will not, Lord,
the lessee will continue. No, lessee will continue.
Lessee will continue. But where is the suspension of his obligation to pay rent? contractual obligation has to continue, whether it is during the pendency of the suit or even thereafter. Irrespective of the result of the suit, he has an obligation to pay. I want him to discharge that obligation during the pendency of the suit. Whatever the decisions of your lordships are, ultimately that will abide by. But now there is no impediment on his depositing the rent in the court. This is what my application is all about. Yes, accept. So, my lord, GA8, I'm sorry. But may I just take your lordship straight to the orders? Because kindly, Lord, come to page. Could you go to another division? Kindly come to page 102 of the petition. Kindly
Yes.
take the petition 102.
Yes. Your petition.
The order, please. Ah, 102.
Yes, this is in page
Lord, page 102 of the
of your application.
yes. I'll put it order.
Yes, 10th April 2024.
10th April 2024. So the trial court's order is at page 97. If your lordships kindly look at the trial court's order before we come to the division bench. First come to page 97, the order of the trial court.
Yes.
EA 823 is filed by the defendant praying for dismissal of the suit, alternatively rejection of claim. Stay of all further proceedings till disposal of the present application, not to transfer the suit, etc. Then note the discussion. Kindly note come to page 99. Around the middle, it says, I have heard rival submissions.
Page 99.
Yes.
Yes.
Around the middle, just below the middle, it says, I have heard the rival
Yes.
submissions. It is settled principles of law that in considering an application under Order 7, Rule 11 of the Code of Civil Procedure, the pleadings contained in the plaint are paramount important. A court shall take into consideration the plaint only. It cannot travel beyond the periphery of a plaint. Subsequent development of facts are questions of facts. If plaint is not amended to incorporate these subsequent developments, the defendant can canvass subsequent development in his written statement. If necessary, the written statement can be amended. But while considering an application for rejection of plaint, four corners of the plaint cannot be transgressed. Then shipping corporation and other, this judgment is taken note of. Your lordships may kindly not turn the page, come to 101.
101.
101, the operative. Mr. Dutt argued further that the difference between section 151 and order 7 are in nomenclature only. The court has power to reject the plaint. I disagree. Exercise of authority to reject the plaint under order 7 Rule 11 is one thing, whereas exercise of inherent jurisdiction under section 151 is another thing. A court can exercise its authority under order 7 Rule 11 to the extent prescribed by the statute. Exercise of inherent powers are also subject to limitation imposed by the different judicial dicta evolved over long passage of time. As stated above, dismissal of the suit or rejection of the plaint as pleaded depends upon facts finding as to whether the suit has become infructuous or cause of action is no more alive but for the orders passed by this court. Mixed question of law and facts are involved. but the plea, if canvassed in the pleadings, may be considered at the time of final adjudication of the suit, but not at this stage in this manner. Accordingly, GA 8 stands dismissed. But this was the trial court's order. The appeal court's order.
So trial court was disposing an application under Order 7 Rule 11.
Yes, it was
Read
a-
with 151.
Read with 151, it was an application filed under that provision, invoking that provision. Then, Lord, the matter traveled to the division bench. If your lordships, my lord, kindly.
Yes, 102.
102 it starts. Kindly, my lord, 104. Kindly see the last paragraph. Either as a result of the subsequent development as pleaded by the appellant defendant in the said application, the suit had become academic and nothing remained, or it had not become so, and the suit ought to be tried and determined. If the answer is in the affirmative with regard to the first proposition, then subjecting the parties to a long-drawn trial would be contrary to notions of justice. It is true that whether the suit had become a spent force or not could not be decided in the application under Order 7 Rule 11 or under Section 151 of the Civil Procedure Code. Order 14 Rule 2 provides as follows. Then, Lord, it is quoted. Please turn the page. If the suit has become academic and infructuous, it goes to the jurisdiction of the court. The court would no longer retain jurisdiction to adjudicate it. Once it is a jurisdictional issue, it can be tried as a preliminary issue before all other issues. This preliminary issue may not be only an issue of law, but an issue of fact and law rolled into one. We are of the view that the question raised in the application before the court below, GA 8 of 2023, should be tried as a preliminary issue in the suit on the basis of the application and the affidavit exchanged thereto before the suit proceeds any further. The learned single judge may direct documents to be disclosed relating to that issue only, invite evidence to be adduced in court or by commission, whichever the court deems fit and proper, and decide the question as soon as possible. Depending on the decisions of the court on that issue, suitable directions may be made, either disposing of the suit or directing that the suit be tried and determined on all issues arising therein. At this stage, Mr. Mukherjee submits that there is a pending application, GS6, before the learned single judge. This was our application for occupation charges. We say that it should be open to the learned single judge to decide in what order the preliminary issue or the pending application is to be entertained by the court. We request learned trial judge to decide on the preliminary issue within 3 months from the date preferably. Then, Lord, the matter goes to the Supreme Court. The plaintiff, Lord, goes to the Supreme Court.
Yes.
Your lordships may kindly see the order of the Supreme Court at page 109. Having regard to the facts and circumstances of the present case, we are not inclined to interfere with the impugned judgment and order passed by the High Court. Page 109. Second paragraph I have read. Third, nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law. Having regard to the development which had taken place pending the suit, both the parties shall also be at liberty to file appropriate proceedings before the trial court single bench as may be permissible under the law. And if such proceedings are filed, the same be considered without being influenced by the observations made in the impugned order passed by the division. We further clarify that we have not expressed any opinion on the merits of the case. Now, my lord, at this stage, GS6 was pending. The division bench direction was that that should be considered by the trial court in the light of the trial court's own discretion. But Supreme Court says that this is a liberty given to the parties. Both the parties shall also be at liberty to file appropriate proceedings before the trial court single bench as may be permissible under the law. And if such proceedings are filed, the same be considered without being influenced by the observations made in the impugned order passed by the division.
No, that means as per the division bench, that preliminary issue ought to be decided. And that was to some extent modified by the Honorable Supreme Court that yes, the trial court may not be influenced by that order.
And
all
it
applications
says-
if made, that has to be disposed.
And it also says that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law. So it's not that you are bound by order 14. It kindly come to 3. Nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law.
That means court can decide the preliminary issue first or preliminary issue along with other issues.
Correct.
That is the option.
Absolutely. And then it says that having regard to the developments which have taken place pending the suit. And then it says both the parties shall be at liberty to file appropriate proceedings before the trial court as may be permissible under the law, and if such proceedings are filed, the same be considered without being influenced by the observations made during it. So, my lord, then what happened is that, Lord, there is an order at page 111. Post order passed by the, or rather, my lord, before that, kindly come to page 107. Before the Supreme Court disposed of the matter, Lord, the trial judge had taken up this application.
Page 107.
Before the Supreme Court decided the pending SLP, on 24th April, the Supreme Court's order is 17th December 2024.
Yes.
24th April 2024, an order is passed considering the division bench's order. It's only the division bench's order which was considered. The lordships will find that it's quoted. The 10th April 2024 order is.
Yes, if the suit has become academic.
Yes. Then, Lord, it says GA6 is pending. Liberty is given to this court to decide in order of preliminary issue or the pending application is to be entertained. Since preliminary issue relates to very authority of this court as observed by the division bench above, this issue should be addressed first. If this court is bereft of its jurisdiction, then any order disposing of GA is a priori, might be infructuous. I agree with the submissions, Mr. Dutt. Since it is mandated the appellate court that preliminary issue jurisdiction of this court shall be decided first, the issues are to be framed at the outset. Therefore, that purpose necessitates the inquiry as to the written statement is filed or not. The learned register original side shall furnish a report on or before the returnable date as to the date of service of the summons, etc. So, Lord, this order was passed.
So this order, okay. So far, this order is passed. This order is binding.
This order is not binding because
No,
Supreme Court order comes later. Supreme Court order is subsequent.
Oh, pursuant, it is prior to Supreme Court's order.
Yes. It is prior to Supreme Court's order following the
Against this, you move the division
against
bench.
the division bench's order.
No, 24th April 2024 was assailed before the division bench.
Lord, division bench's order of 10th April 24
10th April 24
was assailed by the plaintiff before the Supreme Court.
Okay, not this 24th April.
No,
No, in 24th April 2024, okay, at that point of time, the Honorable Apex Court's order was not there.
Not there, and the proceedings were pending before the Apex Court. This is just not within 14 days after the 10th April 2024 order was passed by the division bench. Then, Lord, the Supreme Court's order comes. Supreme Court, Lord, changed the direction passed by the division bench to this effect that liberty was given to the learned trial judge to proceed with the hearing of the suit itself. Number one. And number two, the parties were given liberty to file appropriate proceedings before the trial court as may be permissible by law. So today, Lord, then Lord, kindly see one more order, that is 18th February 2025.
So your application is, there no application is filed. So this is a reconsideration of this earlier application.
Application which I have filed a fresh application.
That means so far GA8 of 2023 is concerned, this is up
I am
to the.
seeking a reconsideration of GA6. Based on the order of the Supreme Court.
So the question is whether GA6 and GA8 are to be heard analogously. That is the question.
So far as GA8 is concerned, if your lordship decides GA8, nothing is to be heard in GA6. Because GA6 or GA8, my contention.
Because you see,
Sorry, not GA8. GA9,
the Honorable Apex Court has observed that, you see, anyway, the court will proceed with the suit in accordance with law. So for GA8 of 2023 is concerned, that means whether anything remains in GA8 of 2023 to be decided after it has been disposed by the Honorable Apex Court.
GA8 has to be decided. GA8 has nothing to, no more surviving. GA8
Yes, after the Supreme Court order, whether GA8 remains or not.
No, it doesn't. I'm talking of GA9 and GA6.
GA9 and GA6.
I'm talking of GA9 and GA6.
Okay, anyway,
GA9
GA6 is pending.
GA9 I have filed pursuant to the liberty granted by the Supreme Court.
Okay.
And I am
so I am hearing GA9.
correct. The Lordship is hearing GA9. And I am saying that irrespective of the decision or the result of the suit, Lord, a tenant has an obligation to deposit rent even during the pendency of the suit. And I am saying that this obligation has to be, the court must direct the defendant to honor this obligation based on the supplemental deed of lease, which is executed pursuant to two settlements.
What are the difference in relief sought in GA6 and GA9?
The difference is that Lord GA6,
Yes.
the learned trial judge refused to entertain after the matter came back from Supreme Court. The Lordship kindly sees 18th February 2025 order.
Page 107.
111.
111.
Yes.
Okay, 111. Yes, what is the order passed?
11 blood is after the order of the Supreme Court, 17th December 2024. When this matter came up.
So this is on 18th February 25.
Yes.
Now 18th February 25.
Yes.
So what is the observation?
Observation is, kindly blood come to page 112.
112.
24th April 2024 order is quoted.
Yes.
Around the middle, your Lordship will find. Then it says that the order passed by the appellate court on 10th April 24 in APOT was appealed before the Honorable Supreme Court in the petition special division. Upon hearing the following order was passed by the Honorable Supreme Court.
Yes.
Then the Supreme Court order
Yes.
is quoted. Mr. So-and-so, appearing for the plaintiff, submits that the plaintiff had filed an application GA6 claiming occupational charges which should be heard pending decision with regard to preliminary issue relating to jurisdiction of the court. On the contrary, so-and-so. Then kindly see the finding. It is found from the aforesaid order that the Supreme Court did not incline to interfere with the judgment and order passed by the Honorable Court. Liberty was granted to the parties to file appropriate proceedings as may be permissible under the law. It is informed that no such further application proceedings has been filed by the parties. At that stage, this application GA9 was not filed. In view of the above, since the appellate court so-and-so observed that once it is a jurisdiction, it can be tried as a preliminary issue before all other issues, it would be appropriate to try preliminary issue at the first instance, pending the application in GA6 of 2020. Now, register original site is directed to comply with the order of 24th April by furnishing a report as to the date of service of the summons, etc.
Now, question here is this regarding the observation of the Honorable Division Bench and the Apex Court. It is observed by the coordinate bench that it is a jurisdictional issues. It can be tried as a preliminary issue before all other issues.
But I'm not joining issue there. I am saying that pending consideration of the preliminary issue.
No, here its observation is pending the application of GA6 of 2022.
Because what it says, it also says, kindly see the last paragraph. It says, it is found from the aforesaid order of the Honorable Supreme
Last
Court.
paragraph, that is?
Page 113.
Yes, page 113.
Can you see the last paragraph?
Yes.
It is found from the aforesaid order that the Honorable Supreme Court did not incline to interfere with the judgment and order passed by the High Court in APOT such and such. Liberty was granted to the parties to file appropriate proceedings as may be permissible under law.
Yes.
It is informed that no such further application proceedings has been filed by the
So
parties.
at that point of time, nothing was filed.
GA9 was not filed. So the court expressed its mind that unless an application is filed in terms of the order of the Supreme Court, the court cannot consider. So, Lord, I have filed Lord GA9.
No, but what is the difference between your GA6 and GA9?
As of date,
the relief claim.
GA6.
Then the question comes with regard to maintainability.
I'll tell you, Lordship. Because Lord, nothing is decided. No question of maintainability.
You see, GA6 is also kept pending.
GA6 and GA9, they are both interlocutory applications where no decisions is taken.
Yes, yes,
So,
both
Lord,
are kept pending.
I can Lord file multiple interlocutory applications. There is no bar.
No, but
there is no res judicata.
No, but new grounds must be there. Grounds must be there.
Your Lordship can dispose of, Lord, record that I am not proceeding with GA6. Entertain my GA9. As
GA6 is pending. Now, if you can show that GA9 gives rise to
GA6
some cause of
I tell
action.
your lordship, GA6 was filed at a point of time
Yes,
where, my lord, the rent was claimed up to a particular time.
right.
Now, my lord, the rent has become due from that particular time till current time, February 2025. So, my lord, I have claimed, my lord, the entire period of up to February 25 from December 19. This is the
That
period.
means including what was claimed in GA6.
Correct. So GA6, your lordship can record that I am not proceeding with GA6. And Lord, I have
Instead of
filed
proceeding, if the court decides one, that will become infructuous, irrespective of whether you proceed or not.
absolutely no issues. No issues. Lord, only thing
Court has granted you liberty definitely, but
Supreme Court.
only thing is this, whether the issue is same or not.
But
That is the
there-
thing.
There are two issues. First case, Lord, there is no res judicata in my filing, Lord, applications. Number of applications, interlocutory applications. I can, Lord, file any number of interlocutory applications. It is up to me to press a particular application and not to press a particular application.
That is there.
There is no bar on my, Lord, limit or limitation on my filing applications. I have filed this application in compliance with the order of the Supreme Court. Because, Lord, the earlier bench, the coordinate bench, was of the view that when the Supreme Court says that on further application, things are going to be considered, I will not consider the earlier application. But, Lord, today I am in a difficult situation. My property is at stake. I don't have access to my property. I don't get rent out of that property. I am trying to secure, Lord, my property, the rent arising out of my property. It is irrespective of, Lord, whether I lose or win my suit.
Now the question comes is, when there is a finding, okay, that it would be appropriate to try the preliminary issue, keeping that GS6 of 2022 in abeyance. Definitely this is binding. Now, whether it would be proper for this court to not to decide the preliminary issue, but to decide GA9. That is the only thing. So far this is concerned, it is binding upon the court. Now whether GA9 can be decided, that is the point of law.
Lord, this, so far as this is concerned, this is by a coordinate bench, whose view was that there was to be an application pursuant to the order of the.
No such further application has been filed.
Correct. So the court was of the view, since no further application has been filed post order of the Supreme Court, I will not consider GA6. Because, Lord, whatever order division bench has passed has merged into the order of the final order of the Supreme Court. The Supreme Court has disposed of the.
Now another thing is this, you see, so far the order of the division bench is concerned. The order of the division bench says that yes, you see, preliminary issue as well as GA6 can be taken up analogously.
Both can be taken up.
And that order was not interfered with.
No, with a further, no, interfered with to this effect. That's the interpretation given by the learned judge, coordinate bench, that it was interfered with to this effect, that
it will not be, trial court will not be influenced by the division bench order.
Division bench judgment and further liberty to the
file
parties to
interlocutory
declare
applications.
So, my lord, either you.
That means you have to show some exigency that up to this 2005, there is some exigency. You are facing difficulties, financial.
I am facing difficulty is that
some exigency, something has to be shown.
DT's property, not a single farthing is coming.
That is GA9.
People are enjoying property. They don't want to pay. This is what, in short, is my difficulty.
Only if there is some exigency which should be taken into consideration, the court definitely will take this GA9 into consideration.
Yes. So, my lord, kindly, in the affidavit in opposition, kindly come to the affidavit in opposition. Lord, they have annexed.
Yes, that is, affidavit in opposition is one thing, and you see the question of whether what the court should do, maintainability. If the court can take up this application, definitely the court will take up this application after considering the affidavit in opposition.
Very good. Now, Lord, if your lordships kindly come to the affidavit in opposition once, your lordships will find that the defendant have annexed the judgment of the apex court, a very recent judgment of the apex court,
Page
127.
127, yes.
সুবিধে করে দিয়েছে, নাহলে আমার দেখাতে হতো। This is annexure E. Has your lordship got that?
Annexure E,
Yes.
127.
It is reported in 2024 SCC online SC 980. Now, your lordships may kindly come to paragraph 15. Or rather paragraph 14.
14, yes.
It is submitted on behalf of the respondent that since no court has declared an end of the landlord-tenant relationship, the petitioner applicant asking the respondent to pay occupational charges as opposed to contractual rent would amount to rewriting of the tenancy agreement. Further, it is argued that occupational charges are only payable after the lease is validly determined or after the decree of eviction. Since both these eventualities are yet to occur, no question of such payment arises. It is also urged that the petitioner applicant accepted rent from the respondent till August 2002, but thereafter refused to do so. Accordingly, the respondent tenant, a total amount of 2,06,000 is payable on their part to the petitioner applicant in the following terms. Then, Lord, there is a chart. The lordships will not kindly take the chart.
No, your occupational charge is last paid occupational charge or as per the terms of settlement?
As per the terms of settlement
Terms of
as directed
settlement.
by the court. I am in a better situation where court has fixed the occupational charge.
Sometimes in case of determination of lease, when there is no defense of the defendant, occupational charges are fixed as per the market rate or whatever it is.
This judgment says that.
Or if there is an eviction decree,
Judgment says that. The judgment, Lord, secures. Lord, there are discussions from paragraph 31 onwards. Lordships will not kindly will not cease. Paragraph. Sorry. Paragraph to the. I'm sorry, I had looked into the SCC volume. So Lord, the paragraphs are not tallying.
yes, paragraph 14.
I'll kindly give you one.
Paragraph 14 is it is submitted on behalf of the respondent.
Kindly give me. Lord, kindly come to paragraph 19, 19. But Atmaram Properties judgment is.
No, Atmaram's case is this. After an eviction decree is passed, during pendency of the appeal, occupational charge.
Correct. Your lordship is absolutely right. Paragraph 18 discusses that principle.
Yes, paragraph 18.
17, Lord Atmaram is quoted. Then paragraph 18, please come to 19. While the above stated position is generally accepted, it is also within bounds of law that a tenant who once entered the property in question lawfully continues in possession after his right to do so stands extinguished, is liable to compensate the landlord for such time period after the right of occupancy expires. Then so and so. Paragraph 64, the Indian Oil Corporation is quoted. A tenant continuing in possession after the expiry of the lease may be treated as a tenant at sufferance, which status is a shade higher than that of a mere trespasser, as in the case of a tenant continuing after expiry of the lease, his original entry was lawful. But a tenant as sufferance is not tenant by holding over. While a tenant at sufferance cannot be forcibly dispossessed, that does not detract from the possession of the erstwhile tenant turning unlawful for the expiry of the lease. Thus, the appellant, while continuing possession after the expiry of the lease, became liable to pay mean profit. Then paragraph 21.
Yes, some distinction is there, you see. In case of premises occupied by a tenant, that is one thing. And a lease of vacant land for development and all these things.
Not vacant land. There was an existing structure. They will demolish.
That means
they will,
they are not occupying. They have to perform something.
But performance is covered by the order of the court.
Yes, yes.
The court has not exempted them from payment of rent.
So entire thing is contractual or by the terms of settlement?
Contractual following
Yes.
the terms of settlement.
So for Atmaram's case is concerned,
No,
it is with
no,
regard to tenancy.
Totally
You have to
different.
vacate the tenanted property. That is the Atmaram's
I
case.
just wanted to place, Lord, this judgment. for the proposition. The court says that a tenant has entered the property. He is occupying the property. He is not depositing.
Similarly, the lessee is also in occupation of the property.
Obviously, I am not concerned. If he has let out the
So
property.
far Atmaram's case is concerned, they have to pay the market rate. But so far the lessee, in this case, they have to pay the
pre-degree stage.
Yes,
You
yes,
have
yes.
kindly consider this is a pre-degree stage where the Supreme Court is considering that even at the pre-degree stage, it is the duty of the court to secure the landlord's payment that is supposed to come to the landlord. That is what the court discusses. Kindly, my lord, come to paragraph 21.
Yes.
Having considered the submissions made across the bar, we note that the disputed nature of the lease deed, in other words, its continuation or forfeiture on account of non-payment, is heavily contested and stemming therefrom. Similarly, the situation here is, if your lordship's lord throw away the suit, even then my contractual right remains. Therefrom, so in the nature of payment to be made, we also note that the location of the demise premises is in the heart of Kolkata, same as this one, Jackson Lane. And if the submission of the petitioner are to be believed, they have been deprived of rent for a considerable period of time. Taking a lock, stock and barrel view of the present dispute, the averments and the documents placed before us, we may record a prima facie view that the respondent tenant has, for the reasons yet undemonstrated, been delaying payment of rent and or other dues payable to the petitioner applicant landlord. This denial of monetary benefits accruing from the property, when viewed in terms of the unchallenged market report forming part of the record, is undoubtedly substantial and as such subject to just exception. We pass this order for deposit of amount claimed by the petitioner applicant to ensure complete justice intercede between the parties. After all, we cannot lose sight of the fact that the very purpose for which a property is rented out is to ensure that the landlord by your property is able to secure some income. If the income remains static over a long period of time, or in certain cases as in the present case, yields no income, then such a landlord would be within his right, subject of course to the agreement with their tenant, to be aggrieved by the same. The factors considered by us have been referred to in Martin and Harris Sutra. We are supported by, in our conclusion, by the observations and guidelines issued by this court in Muhammad Ahmed versus Atmaram Chahan. We reproduce the ones relevant to the adjudication of the present dispute. Then, Lord, this is kindly come to 22. Since the specially petitions are pending adjudication, make it clear that the directions made in the above stated interrogatory application hearing are subject to final outcome of the former, keeping in view the location of the demise premises, the rent as agreed, and the alleged non-payment of rent, the default in payment of interest as alleged, and other such things factor. We are inclined to accept the calculation of dues as made by the petition applicant, submitted, etc. Consequently, keeping in view observation made in Super Max International, we direct respondent to deposit. So, Lord, this is the balance of convenience that the court is thinking. He wants the preliminary issue to be decided. Decided. I have no objection. But in the meantime, I'm not asking for payment to me as directed by the court. They were bound to pay. 2019 November, Lord, they have paid the rent. I am saying, Lord.
No, this preliminary issue was raised in which year?
Raised in 2024.
So 1985 it is pending from 1985.
This is 85.
And this issue is raised in 2024.
24. And 24, this issue is raised after GS6 is filed, asking them to pay the occupation charges. Just to prevent that application from being heard, this GA8 is raised. Now GA8 dismissed. Now Supreme Court says you decide. You decide. I have no objection. Decide whether the suit survives or it doesn't survive. But not, I don't lose the property. Even if my suit does not succeed, I don't lose the property. My property remains. And the supplemental deed, which has been executed consciously, it has not been revoked as of date. It implies, it puts liability on the defendant to pay rent. So, Lord, this is what I want to, Lord.
And one thing is this court has to carefully consider the observation made by the division bench, what this court should do, as well as the observation of the Honorable Apex Court.
Lord, if your lordship
that has to be complied with.
Of course, that is
careful consideration.
That is the crux of the matter. If your lordship comes to a conclusion that division bench judgment and Supreme Court judgment prevents your lordship from passing an order protecting my right with regard to
Then
occupation
that
charge.
application cannot be gone into the merits.
Correct. Absolutely.
And that has to be kept in abeyance.
The question is, Lord, how long? Do I continue to wait for payment of rent?
Yes, whatever is the observation of the division bench and the apex court, that has to be followed in letter and spirit.
Yes.
That is
But
the
look,
thing.
My humble submission is twofold. GS6 pendency was taken note of by the division bench. Division bench did not scuttle the hands of the learned trial judge with regard to hearing GS6. Could not have, because Lord, the issues are totally different. Preliminary issue will be deciding the fate of the maintainability of the suit at this distant point of time. And occupation charges is an obligation of the defendant, which the defendant is to discharge to be occupying the property.
You see, both 6 and 9, both are occupation charge. This is subsequent additional occupational charge and some exigency you have, which you have claimed.
Absolutely.
That is GA9.
Correct. But I say
Yes.
two things. First is that division bench's order does not scuttle my application of GA6. Division bench kept it open for the learned trial judge to decide. Supreme Court.
Let us once again come to the division bench order.
Please come to the division bench's order. It is in my petition, page 102. Kindly come to page 105.
105.
Kindly see the third last paragraph. At this stage, has your lordship found that?
Yes,
Third
at
last.
this stage.
Mr. Mukherjee submits that there is a pending application before the learned single judge. We say that it should be open to the learned single judge to decide in what order the preliminary issue or the pending application is to be entertained by the court. So, my lord, division bench kept the issue open. It did not
To the discretion of the
discretion of the learned
trial
trial.
judge.
Now, this discretion, in my humble submission, Supreme Court also kept Lord open for your lordships.
Now, only thing is this single judge, that is the coordinate bench, this bench, by the earlier order thought fit that what preliminary issue, whether preliminary issue or the application should be considered. The court observed that.
I'll come to the learned
That is
single
the
judge.
thing, two-line observation.
After the division bench, matter goes to the Supreme Court. Now, my lord, kindly see what the Supreme Court says. The Supreme Court says two things. Supreme Court enlarges the discretion of the learned trial judge. Supreme Court says you can hear out the suit itself. Kindly see page 109. Para 3. Nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with the law, having regard to the developments which had taken place pending the suit. Then both the parties shall also be at liberty to file appropriate proceedings before the trial court single bench as may be permissible under the law, and if such proceedings are filed, the same be considered without being influenced by the observation made in the impugned. So, my lord, two things. First, Lord, Supreme Court exercised its discretionary jurisdiction to enhance the discretionary power of the learned trial. It said that not only the preliminary issue, you can hear out the entire suit. This is number one. Number two, the Supreme Court says that parties are given liberty to file application, and those applications will be disposed of without being influenced by the observation made in the impugned order passed by the division. So, my lord, my humble submission is there is no fetter, so far as your lordship is concerned, in directing deposit of occupation charge.
That means hearing your application.
Correct.
And thereafter directing.
Absolutely. Hearing my application on GA9, because Lord, earlier the coordinate bench, post order of the Supreme Court, felt that there being no fresh application, the coordinate bench was not in a position to consider. So, Lord, I have filed this application, GA9, for the purpose of a direction on the defendant to deposit rent. I'm not asking, Lord, for payment of money. I'm saying the defendant be directed to deposit rent to secure the ends of justice. Now, Lord, two things I am just going to submit more.
Now it's 3:30. So there is a.
I see.
Today there
yes,
is-
yes.
Today there is 3:30.
So, Lord,
So you'll
give me
continue. How long will it take next day? On the next
10,
day?
15 minutes maximum, just to summarize on this.
So
point.
Mr. Dattu will
Yes.
thereafter submit.
Yes.
হ্যাঁ, বুধবারে দুটোর সময় আছে কিছু ম্যাটার? দুটোর সময় কি তিনটের সময়? বুধবারে কি দুটোর সময় আছে না তিনটে? দুটোই আছে। তিনটের সময় আছে। So can you come tomorrow?
Yes, tomorrow. From 2 to 3, I am free. If your lordship, sir.
কালকে দুটোর সময় কিছু নেই।
Another, give me just 15 minutes to conclude. That's all.
Yes, Mr. Dattu, I'm keeping it tomorrow.
Your lordship gives.
Yes, record an order. Learned counsels for the parties are present. Mr. Kaur, learned counsel for the plaintiff petitioner, submits but could not conclude the same. Let this matter appear on 10/6/2025 at 2 p.m.
Much.